One.
Good morning and welcome to this licensing hearing. The first item on the agenda is to appoint a chair for the meeting, and I understand that members would like to appoint Councillor Mason. Is that agreed?
Yep, thank you.
Thank you, members. I'll now hand over to the chair.
Thank you. Good morning, everybody, and welcome to this licensing subcommittee to determine the application for St George's Place. I'll take us through the agenda first before we get to the main item. So the first one is introductions, and I'm aware we've got quite a few people around the table. So I'll try and list some of the people for the benefit of those involved in the meeting, but I don't propose we go through every single representor. So I'm Councillor Ashley Mason. I'm the chair of the city's main licensing and regulatory committee, and obviously chair of the subcommittee. I've got Councillor Norman with me. If you want to say hello, Councillor Norman.
Hello.
Thank you. And Councillor Melly, who I can't see on my screen, but is there hopefully somewhere.
I am, yes. Good morning.
Brilliant. Alongside that, obviously, we've got Fiona Young, who you've probably dealt with already, who's our democracy officer, who's clerking the meeting and supporting us. We've got Sandra Brannigan, who's our legal advisor to the meeting. And then obviously we've got our technical support team in the background, who you've obviously already spoken with. Leslie Cook is the licensing manager, and will present the application at that time. And then obviously we've got, in terms of representors, Leo Sharolambides is the barrister representing the majority of the representors, and Mr Bryce is representing himself, and I think Councillor Crawshaw is also a witness for the representors, and Mr Cowton is the applicant, and he's representing himself. I think that's everyone. Michael Golightly is from the Council's Public Protection Department, and obviously he's representing himself and their department's concerns about the application. I think that's everybody. I don't propose we go through everyone else, but hopefully that gives people a flavour of who's in the room and why. So item 3 is declarations of interest. Members, is there anything that you wish to declare?
Nope.
Brilliant. One thing I'm going to mention, it's a personal non-prejudicial interest. I'm a member of the Company of Merchant Adventurers, and I'm aware that a partner of one of the representors who isn't named in any of the paperwork is also a member. So it's already on my interests register, but just want to be absolutely transparent and make that clear at the start of the meeting. So that takes on to item 4, which is exclusion of the press and public. Licensing hearing decisions are made in private. So obviously, once we've heard all the evidence from both sides, we'll then virtually retire, make our decision, and then people will be informed of that decision later on today by it being published on the council's website. Right, that gets us to item 5, and that's the determination of the application. Just before I asked Leslie to present the application, obviously you'll be aware that Mr Bryce shared some information with the council. I think it was on Friday. That information has been circulated to all parties as far as I'm aware and concerned. So I just wanted to make it clear that we're happy that we can include that information in today's hearing. Right, Leslie, can I ask you to present the application to us?
Thank you, Chair. This is the application for the grant of a premise licence for 6 St George's Place, York. The licensable activities applied for are the sale of alcohol on and off the premises, Monday to Sunday 11 AM till 11 PM, opening times Monday to Sunday 11 AM until 11 PM, with non-standard timings of 11 AM to 1 AM on Christmas Eve and New Year's Eve. A full copy of the application and plans submitted by the applicant are attached at Annex 1 of the report. This premise is described in the application as a hotel with 10 ensuite bedrooms, a dining room and an outdoor area with 8 individual glass pods in the rear garden. As part of the application, the operating schedule submitted by the applicant showing how the licensing objectives would be met can be found at pages 8 and 9 of the report. I can confirm that this premises is not located within the community of impact area and that the consultation process was carried out correctly. North Yorkshire Police has mediated with the applicant during the consultation process and has agreed to conditions being added to the licence if this licence is granted. The agreed conditions can be found at Annex 3. The City of York Council's Public Protection have made representation based on the prevention of public nuisance licensing objective, and their representation can be found at Annex 4. 19 relevant representations have been received from other parties, and the list of the representatives can be found at Annex 5, with their representations found at Annex 6. Additional information has been supplied by the representatives, which has been published as an agenda supplement, and as you have just said, Chair, further information from one of the representatives was circulated via email at the end of last week. A map showing the general area around the premises can be found at Annex 7. The committee has the following options when making your decision. Option 1, grant the licence in the terms applied for. Option 2, grant the licence with modified additional conditions imposed by the licensing committee. Option 3, grant the licence to exclude any of the licensable activities to which the application relates and modify, add conditions accordingly. Option 4, reject the application. That is the report, Chair.
Thank you, Leslie. Now what happens is that parties have the chance to ask questions of the licensing officer before members. So, Mr. Cowton, have you got any questions you'd like to ask of Leslie Cook?
No, thank you.
Thank you. Mr. Lambides, any questions of Leslie?
Sir, yes. Leslie, on page 27 of the agenda, Mr. Cowton identifies himself as the proposed DPS, and he says the application is in progress. Do you know whether that application has been progressed and whether he has a personal licence and able to be a DPS?
Because I need to just log into another section of the council, if you can give me a few minutes, I will be able to answer that question for you.
Okay, so if I could just park that with you, just so we can know where that is. And then in terms of the premises, it's described as a 10-bedroom hotel. It in fact operates as an unmanned bed and breakfast. Is that correct?
I know where the premises is, but until we got the application, I have no knowledge of this premises.
Okay. In terms of the plans themselves that attach to the application, they don't show where the alcohol will be stored, where the alcohol will be served, or indeed the outdoor pizza oven, do they? Page 33.
No, they don't.
No.
They don't indicate that, no.
No.
And I can confirm Mr. Cowton now does have a personal licence.
Wonderful, thank you very much.
Okay.
I think those are my, let me just check. Nope, those are my questions, thank you.
Thank you. Right, now what happens, Mr. Cowton, is it's your time to present your case and outline your kind of application, any main points you want to address. Normally there would be a set amount of time for that. Obviously, Mr. Lambides may take more time given he's talking for more people, but I think if you could keep it around 20 minutes, that would be appreciated.
I'm sorry, I would like to ask questions of the licensing officer as well.
I have asked you and you said you didn't have any. Is this
No,
a
I
new
didn't.
question based on the last remarks?
Sorry, no, you only asked Mr. Lambides. And he spoke.
Sorry, I thought I'd asked you.
No, you hadn't.
Okay, yeah, you may ask Leslie Cook a question.
Yeah, I just would like to ask, this is an application for a license to sell alcohol. I'm just a little bit perplexed how this could have been, the plans could have been validated. When on the plans there is no bar. Where is the bar going to be? And also, as Mr. Lambides has touched on, where will the alcohol be stored?
It isn't necessarily that a licensed premises would have a bar. It could just be stored in a fridge in the kitchen. You don't have to actually have a bar to be able to sell alcohol.
And okay, so could the bar be anywhere on the premises? And what exactly are the premises that are the licensable premises here? Is it just the garden, or is it the whole of the hotel?
From the plans that have been submitted, it's the whole of the hotel and the garden.
So that all 4 floors, or any of the 4 floors of the hotel, could be used for the consumption and sale of alcohol, plus the whole of the garden?
From the plans that have been submitted, yes.
Right, thank you.
Sorry, Mr. Bryce. Yeah, you're right. I didn't ask you. Sorry, I was
That's
looking
okay.
at a different image on the screen. Members also, is there any questions from members for Leslie?
No, thanks.
Okay. Right. Sorry. Now, Mr. Cowton, it's your chance to present your case. Like I said, if you can keep it around 20 minutes, that would be appreciated.
Thank you very much, and good morning, everybody. Thanks for making the time for the hearing. Yeah, I just want to make some opening remarks about what it is we're trying to do and why I've applied for the alcohol license. What we're not wanting to do is to open a beer garden or a bar that's generally open to the public, in the sense of, for example, a pub. The context of the application is a direct response to the problems caused by COVID and especially the availability of safe spaces to eat and to meet. So that was where the idea came from. And the primary objective is to provide an extended service to our guests. But we do also want to extend those services to people in the area, local residents, and anybody who wants to have a safe dining experience. We're doing this to enable the business to survive, or it's an attempt anyway, to help the business to survive, and also obviously to protect livelihoods and jobs. We think that the dining facility is a positive enhancement of what we currently offer, which is bed and breakfast accommodation. And we want to be providing safe and welcoming dining facilities, both for our residents and for non-residents, but only on a pre-booking basis. We are not we are not going to be taking walk-ins because it simply wouldn't work, because we would need it, at the very least, everybody's name and address and contact details for the purpose of track and trace, amongst other things. I regret not being able to hold any local meetings to listen to respond in person to concerns, but a lot of that has been driven by the COVID restrictions and the fact that I am in fact shielding. But I am, and I always have been, available at the end of the phone. The business number is obviously in the public domain, as is our email address. And I haven't been contacted by anybody apart from one local resident who wanted to know when we were open because she thought it was a great idea. So the main principles are to, as I've already stated, are to be able to provide a safe dining space. And we put a lot of thought into the design of it. We think that the area itself is poorly served with amenities, and we see that as a positive enhancement. The advantage of the glass pods is that, of course, they are safe in the terms of being able to host between 2 and 6 people, although we envisage it would normally be smaller groups. And they're, of course, weatherproof, which is a big advantage granted the English summer. We've also wanted to keep it the indoors outdoors, or the outdoors indoors, so to speak, because what we didn't want was a beer garden with picnic benches in or anything like that. So the structure of the glass garden means that it's all very self-contained. We've used high quality materials and a high level of design because the garden was previously quite a neglected and unused area. So we also wanted to visually enhance the aspect of the garden. Our operating principles are that it will not be a bar and it will not be a beer garden. We are not going to be serving alcohol except for guests who are here for a meal. And we will not be admitting guests to the garden area who are either not residents or who have not pre-booked with their name, address and contact details. These are our operating principles. There will not be a bar area in the garden, and the pods will not be bookable for drinking. As I said earlier, the condition of us selling alcohol is with a meal or with food. But we do not want and have never wanted the pods to simply be an attraction or a magnet for people who want to drink alcohol. It's about the food, and the alcohol is to enhance the offer of food. It's complementary to the food. We're not open to stag and hen parties. We never have been, and we don't intend to be. We do not turn race goers away, and I think we have a very good experience with race goers in the main, but we will not be opening to anybody, including race goers, unless they're booked with us beforehand or unless they're staying in the guest house. As things stand, we do not accept bookings from parties of more than 6 people, and that is not, we're not going to change that policy. Regarding any off sales of alcohol, we are not selling alcohol to anybody who has not booked to eat in the restaurant. The idea of off sales of alcohol was simply for if a guest had particularly enjoyed their bottle of specially imported Italian wine, they might want to buy a bottle or two, either as a souvenir or to take with them. So that was the idea of that. In terms of the measures that we are taking to minimise disruption, because we are aware that this is a new venture and that we are in a residential area, we're limiting the capacity of each pod to 6 people. I don't think mostly there will be 6 people. I think it will be probably couples in the main. We will restrict the number of guests in the garden area at any time to 48, because that would be the absolute maximum. I don't actually expect that to ever happen. The garden will not be open to members of the public who have not pre-booked accommodation or a meal. This is all down to controlling the flow of guests and making sure it's all, perfectly manageable and a small scale private dining experience as much as anything else. In terms of the opening hours, we have listened to people's concerns regarding the timings, and what we are proposing is that we serve last orders of food and drink at 9 o'clock on Sundays through to Thursdays, with lights out at 9:30. On Fridays and Saturdays, we propose the last orders would be 10:30 with lights out at 11. Some of the responses, the representations centred on our failure to obtain planning consent. I hope I've cleared up that misunderstanding. Before, which I see in it's in the annex, before commencing any work, I submitted a commercial inquiry, and I was informed at the time that on the 5th of November that the planning permission was not required. So it's on the basis of that I went ahead with the plan to construct the dining pods. Planning enforcement subsequently came to visit, and it confirmed that we did in fact need to submit full planning permission because of the fact that I had put some concrete bases down for the greenhouses to make them more stable. Ironically, I wasn't going to do that, but one of my neighbours suggested it was a good idea and that the way I was going to be putting them up wouldn't be sufficiently stable. So when we were told that we would need planning permission, then that was duly submitted. And that's in progress. I'd like to now just clarify some of the points under the operation schedule for the dining pods. And I acknowledge that I hadn't anticipated the level of concern that has been raised about various aspects of this venture. And I think a lot of those concerns have come from a misunderstanding of what it is we're trying to do. I'd like to address the point of minimising alcohol-induced antisocial behaviour. I honestly don't anticipate that being a problem because we're only serving alcohol with meals. We're not going to be letting anybody using the dining pods for drinking alcohol without a meal. It's an accompaniment to the meal. So I think it's unlikely this would lead to antisocial behaviour. The second point raised was about the increase of crime and disorder through off-sales of alcohol. We will not be selling alcohol except to guests who are eating in the restaurant. And any off-sales will, of course, be in sealed containers. Disruption in an otherwise quiet neighbourhood. We are operating a booking system, making any increase in crime and order very unlikely. Everybody's going to be giving their names and addresses. No walk-ins are going to be accepted. So all the guests on the premises will have pre-booked. Some residents are concerned about racegoers being attracted, which is a moot point at the moment, of course, with there being no races, but looking into the future. But there's not going to be a facility for any racegoer unless they booked to eat or they have a confirmed booking at the hotel. But even then, they will not be using the pods, even if they are a resident, just for the purpose of drinking. As I've said earlier, they're not going to be used for that. We didn't think then, granted that's the way we were going to be operating, that we would need to employ bouncers or door staff. And there will always be 2 fully trained staff at any time anyway on the on-site and 3 during busier times. In terms of communication with residents, as soon as this is permitted under COVID restrictions, we will gladly hold regular meetings with neighbours and ward councillors in order to ensure that the operation of the restaurant is a positive experience for residents, not a negative one, which is what is being perceived at the moment. And we're always available to listen to and respond to any concerns via email or phone. I'd like to address the second objective, which is public safety. In terms of fire safety, we take that extremely seriously. We use all the risk assessment guidelines that are freely available, and the public safety measures we think will be adequate. We've already had a site visit from a company that specialises in fire safety, and once planning permission, well, depending on planning permission, we will obviously be installing fire exit markings and making sure that all the electrical installations, etc., are completely compliant with regulations. In terms of serving alcohol safely, we have commissioned a professional CCTV installer to advise on what is required in terms of a CCTV system to cover the premises. And this will, of course, be fully compliant with what the police have recommended. safety of guests and the minimising of disruption is a very important aspect of how we are working. So there'll be nobody on our staff who hasn't been trained regarding their obligations under the Licensing Act in respect to age verification and the retail sale of alcohol. And we will, of course, be keeping all the records that we need to keep, including a refusals register, incident report register, and so on. Also, we were not going to be selling alcohol late at night. During the week, we will close at 9 o'clock, or last orders rather will be at 9 o'clock, and 10:30 on Friday and Saturday. There will also be clear and legible notices requesting patrons to respect our location in a residential area. And this will also be made clear in our booking confirmation email and texts prior to guests actually arriving. We'll be operating the Challenge 25 age verification policy, and there will be no off sales of alcohol except to guests who have booked, and they will be, of course, in sealed containers. In terms of security at night, we have a night manager who is not on site currently, as we're operating currently, although we do have provision for that should the need arise. But the night manager is less than 10 minutes away, and the CCTV system we're having installed sends alerts, of course, when there is any movement detected, and it can be logged into remotely as well. In terms of traffic, which has been highlighted, we don't think that the increase in traffic will be significant, as we will be limiting the maximum capacity of the restaurant, and we will be prioritising hotel residents. And in any case, we will be directing non-resident guests to the parking on Knavesmire Road, which isn't terribly far away, within easy walking distance. Some people have mentioned under the danger from a fire pit, which again, I think is a misunderstanding of what the fire pit is going to be. It isn't a pit as such, it's a fire bowl. I think there was a report in The Guardian which alarmed some residents, but then that was journalistic rather than factual, shall I put it that way. The fire bowl is conceived as a purely decorative feature. And it is actually raised off the ground. This is if we go ahead with it. It is a 2 meter wide steel dish with an LPG burner in the middle, but the burner is less than half the actual dish. In terms of the objective of prevention of public nuisance, we will have 8 pods, and we have, if you include the space in front of our hotel, 7 car parking places for the use of guests. Again, I think I've sort of covered that in terms of the traffic point as well, which is that we will, of course, be directing non-resident guests to park in Knavesmire Road. And again, because we have a pre-booking system, we think that will work quite well. We will not be saying you can park in St. George's Close. We'll be telling them where the available free parking is. In terms of noise nuisance, we don't anticipate there will be a lot. I mean, we've done our own tests using decibel meters of what the likely noise from the pods would be. It doesn't seem to significantly exceed any existing background noise anyway. There'll be no music in the garden or no facility for playing music in the actual, in any outside area, in the open area. But the other point is I don't think the closing times that we're proposing are particularly disruptive. With lights out at 9:30 on any weekdays and 11 o'clock at Friday and Saturday, there will be no access to the garden when it is staffed. It will be secure. The dining pods themselves are lockable, and the garden area itself will be fenced off and locked. It's also surrounded by pretty high walls, 2 meter plus walls on 2 sides. So there'll be no amplified music in any outside space. There'll be no guest dining areas in the garden that are not fully enclosed by the greenhouses. And these have got toughened glass and a double skin polycarbonate roof. So we don't think that the noise will be detrimental to neighbours. In terms of deliveries, we won't be getting deliveries earlier than 9 o'clock, and there'll be none on Sundays and bank holidays. And rubbish collections, they're just once a month and they don't happen before at antisocial times. Litter was an issue. We're not going to be selling takeaway food or drink, so we don't think there'll be any increase in litter at all. As expected, there'll be a designated smoking area. Toilet facilities were mentioned. We're installing 2 new guest toilets in the basement, which is less than 20 metres away. There'll be a total of 3 guest toilets and 3 wash hand basins, which is more than adequate. In terms of managing guest behaviour, the dining area is at the rear of the hotel, so there'll be no possibility of guests drinking or eating in the street or pavement, and we're limiting group sizes to 6.
If you can start to wrap up now, please, Mr. Cowton.
Sure. If I can just cover the prevention of children from harm, it's a family-friendly development we've got, and it's a family-friendly hotel, and we're proud to be able to offer this facility. Children won't be allowed onto the premises except when supervised, and the garden isn't visible from the street, so we don't think that we are going to be in any danger of causing harm to children by having a discreet restaurant to the rear of the property. So my sort of summing up of that is that we are not proposing running this restaurant in a way which would cause any nuisance or harm to children, and we've taken as many mitigating measures as possible in order to make sure that this does not cause any disruption to the residents in the local area. Thank you very much.
Thank you. Mr. Golightly, have you got any questions for Mr. Cowton?
Yes, Chair, I do. Mr. Cowton, you say that you did the tests for the noise coming out of the pods. How was that done?
We did them ourselves. I have contacted a company that can do a report for us, but at this stage in proceedings, I'd wanted to assure myself that we weren't going down an unrealistic path here. So we did the tests. We did 2 tests. We did one by we put some music on in the pod at a reasonable volume, probably louder than people talking, and then we stood 2 meters away from the pod. You could barely hear it, and then we did another test with the door open, the door and the windows open of the pod, and there was some sound leakage, but again it wasn't done by a professional company, but we just used our discretion, we used our common sense as to whether or not it was a noise likely to cause a disturbance.
Right, okay. So it wasn't carried out by a qualified acoustician then?
No, it wasn't.
Okay, because the only issue that we'd have with that is we'd want to have a qualified acoustician do the report, because, for example, noise can be subjective from hearing, depends upon what your hearing levels are, etc. Also, we want to know what the noise levels are inside, what the reverberant noise levels are inside. You said you used a decibel levels. What machine did you use for that?
Just use an app on the iPhone for that.
Right.
As I say, we just wanted to have an idea ourselves, and we didn't feel that it was necessary to get a qualified acoustician to do that for us.
Again, there's lots of you can have lots of discrepancies with that. For example, it's normally when we're looking at noise reports, we're looking at, has the machine been calibrated? What machine level are you using? Has it met the certain criteria you need for a noise level meter? What is the reverberation time inside the building? What sound coefficient? What sound reduction index did you get through the glass? There's lots of different things that we'd need to have in order to have a robust report. So I appreciate you've done that, but I think it probably wouldn't be sufficient for what we'd want.
I completely agree. I'm not pretending it was robust, and I haven't written a report.
Okay, I think that's the question really. So it wasn't done by a qualified acoustician. So we haven't got any actual scientific data as to how much noise would be.
No, the point about the noise is that we have looked at that point ourselves and come to our own conclusions. But no, we have not produced a report, nor have we got any calibrated equipment which enabled us to make a professional assessment.
And did you do it in one pod, or did you do it in all of the pods at the same time, as if they're all being used at the same time?
We haven't done all the pods at the same time as of yet, because all the pods are not up yet.
Okay, thank you very much. That's all. Thank you.
Thank you. Mr. Sharolan Beeders, obviously normally we would have 5 minutes. Respect you speaking on behalf of a fair amount of people, so I'm prepared to be slightly more generous if it's needed.
Well, sir, I certainly need a great deal of time. I find myself personally quite confused about this application, so I don't really understand it. So I would like some details for what exactly it is that we're planning. So my first question is this. Am I to understand that this is an application for the sale, supply and consumption of alcohol only in the pods? Mr. Cowton.
No.
Right.
No. The sale of alcohol would be, there may be guests who want to eat in the hotel.
So this is an application for the sale, supply and consumption of alcohol in the pods and in the hotel?
Correct.
Where in the hotel?
In the dining room.
How many covers does the dining room have?
That depends on COVID restrictions.
Let's put COVID restrictions to one side. How many covers does the dining room have?
It could have, I imagine, 16.
I'd like you to put your imagination aside, because you need to have undertaken a proper risk assessment. How many covers does your bed and breakfast actually have in the proposed dining space?
We have 8 tables, and each table seats 2 people.
Is there a map with the covers of the dining space and the bed and breakfast provided with this application?
No.
No. And in terms of your various development works, I understand you're digging up your basement and so on. Is it the case that the dining area will be no larger than 16 covers, or is that likely to change either as a result of planning, as a result of your imagination, or future developments?
Sorry, what was your point about the basement?
I'm just asking, as a result of the developments that are happening at this site, both with permission and those being done without permission, is the dining room likely to move? Are the number of covers likely to change?
No.
So if your application were to be granted, you can agree with the committee that there would be no more than 16 covers at any one time in the dining room area.
Yeah.
And in terms of the limits on the sale, supply and consumption of alcohol, does that apply in the dining area as well in the pods, or is that a different set of considerations?
No, it's not a different set of considerations.
So the dining room in the bed and breakfast you're proposing on Sundays to Thursdays will end at 9 o'clock, and the lights out in the dining room as well will come down at 9:30.
I would have thought that for residents, for non-residents, yes, but for residents, no, not if it's inside the hotel.
So your operating schedule in the hotel will apply that you will operate the restaurant for residents to the times applied for, but for non-residents, it will be to the times that are being limited.
For non-residents, we would limit it to the times for non-residents, because obviously non-residents, people who are already in the hotel and who are staying in the hotel, the residents, I wouldn't have thought it's reasonable to chuck them out at 9:30 on a weekday if they're inside the hotel.
And if you
and they are residents.
Well, I mean, you control the opening and operating hours of your dining room. If you have residents staying in the hotel and they have arranged to dine with guests who are not staying in the hotel, would they be able to move into the dining room and enjoy the later hours by moving a number of tables together? Have you considered that?
We would not have any groups more than 6, but I wouldn't have a problem with that, no.
Yeah. So how does it fit with the proposed conditions then? Which hours apply? Are you going to separate the groups and say, well, you're not a resident guest, so you must now leave? Or have you not?
We haven't really anticipated that arising.
No. Okay. In terms of your pizza oven, that's not located in the plan, is it?
No, it's mobile.
Will the general location of it, it's been described as being put outside, will that be able to operate after the close of the pods so as to provide pizzas for members dining inside?
No.
No. So there's a condition that will also operate only until 9 and 10:30 on Friday and Saturday.
Yes.
Now, how do you assess what food is complementary or, what alcohol is complementary or enhances the food offering? Could I have one pizza and 6 of us sit around with the fine wines that you've described?
That's an interesting question. It's obviously open to interpretation, isn't it? But we won't be serving Scotch eggs. So I think we would be, we would use our judgment, as of course you have to do in these, everybody has to do, don't they?
So you don't have a risk assessed formula that you're able to suggest to the councillors in order to meet that particular...
I think it would be obvious if guests were using the pods for drinking purposes, and this isn't something we want. It's not in our interests.
Other than kitchen staff, how many people are you going to have supervising the pods in order to make sure that the obvious is complied with?
A minimum of 2.
So there's a minimum of 2, and their duties are unrelated to food service, taking orders, and so on. They're just there in a supervisory capacity, are they?
No, not at all. No, we wouldn't have 2 people simply watching guests eat and drink. That would be ridiculous.
So they will have all the tasks associated with taking orders, taking drinks.
Well, they won't be taking orders. Orders are going to be done via an app, but they would be serving, yes, of course. But there would be a restaurant supervisor who is not involved in the nitty-gritty of the serving and cooking. Restaurant manager, if you like.
Now, you've mentioned this this back garden restaurant as a response to COVID, but your intention is that this is going to continue long after COVID, isn't it?
I'd love to share your optimism that there's going to be a long after COVID, but I think I think the restaurant will be in place for yes, for a number of years, if that's your question. Nobody has got any idea about how long COVID is going to be a problem for, have they?
There's no time limit to your application. You are planning to put a restaurant in your back garden for, well, for as long as the premises license lasts.
That's correct.
Okay. Where is the smoking area? Because that's not shown on the plan.
No, we haven't decided yet.
So you've not decided the smoking area yet. Even in your imagination, can you imagine where the smoking area might be?
Yes, I can.
Can you tell us where that is?
What, where we might put it?
Yes.
Well, we would put it almost certainly. There's a little space in between the. It's in the car park basically, where you wouldn't normally. There isn't quite space for a car to park, so that would make a good smoking area. It would probably be there.
So that's at the front of the house, is that
No,
right?
it's at the back of the house.
At the back of the house.
Yeah.
On the plan, does the parking area at the back of the house abut to or neighbour any of your neighbours? I'm just trying to see where it is at the back of the house.
The parking, the car park it abuts to the boundary fence of number 4.
And that's on, is that on Mount Vale Drive?
No,
George's Place.
St. George's Place.
I see. So
It's in between the garden and the hotel. So it's an obvious place for a smoking area as well.
So this smoking area, have you made any arrangements for it to be supervised, covered by CCTV, or to control the hours?
It will certainly be covered by CCTV, and we would not expect to be putting a time restriction on it.
So,
I mean, the garden's going to be closed at the times that we've already mentioned.
except that the smokers will be able to come through the garden.
No, they
to
won't.
the smoking area.
Not outside those times they won't, no, because the garden will be closed. There'll be nobody in the garden.
So after 9:30 on a Sunday to Thursday, there is no smoking area.
Well, if a resident guest wants to smoke, then they will smoke, won't they? And one would hope that they would use the smoking area, but there's no sort of there's no legislation that covers that, as far as I'm aware.
So there's no regulation of what happens by your guests that want to smoke. So if, for example, they've had their pizzas, they've taken their bottles of wine, they continue to drink them in the dining room or in their rooms, and then they want to continue smoking, they can continue to access the garden to get into the smoking area at any time.
No, the smoking area is not in the garden.
In the outside area neighbouring number 4. Is that right?
I guess it's possible.
But you haven't risk assessed that or made any provisions for that?
No.
Have you undertaken your risk assessment in accordance with the guidance set out in the Section 182 guidance issued by the Secretary of State?
I'm not familiar with that. Would you like to tell me what repeat that question?
You've not considered the Section 182 guidance and the guidance in terms of risk assessment that are required upon you as an applicant to undertake pursuant to the Section 182 guidance?
I can't answer that question.
No, I take it you don't know what the Section 182 guidance is.
Well, I don't. I followed the guidance. I can't remember whether it was Section 182 or what. No, I'm not a lawyer.
No.
Mr. Chambers, you've had about 12 minutes now. Can you start to draw it in a little bit if you could?
Well, I haven't even begun to look at the operating schedule and the revised operating schedule.
How much longer do you think you'll need?
Well, I think so. What's apparent is that this application is prepared on a very naive basis by someone with very little or no experience of the licensing process. So I think it will just be painful to continue any further. I suspect my point has been made on the basis of the questions I've already asked. So I won't delay you any further. And I'm sure that our neighbours and or yourselves may have questions as well. Thank you.
Okay. Mr. Bryce, have you got any questions of Mr. Cowton? You've got 5 minutes if you need them. You're on mute. There you are.
I have questions for Mr. Cowton. Looking at the plan on page 33, could he explain, I mean, that's the one where the pods are. what floor is shown of the house? Is it the basement or the ground floor? Is that Mr. Cowton? You're muted, I think. Hello?
Yeah, I can hear you. Mr. Cowton, can you hear that question? You're on mute.
Could you repeat the question, please?
On page 33 of the agenda, the plan of the pods in the garden, part of the house is shown. Which floor of the house is shown on there?
That's the well, it's the footprint, so it would be the ground floor.
The ground floor?
Well, the ground or the basement. No, sorry, it's the basement, isn't it? Yeah.
It's the basement. Okay, so on page 35, we have a plan of the ground floor. Is that correct? It's a nice clear plan. And then
One second, let me just find it.
I'm concerned about time. Pages 39, 37 and 35 show clear plans of the second, first and ground floor respectively. Why have you not submitted with your application a clear plan, as clear a plan as the other three, of the lower ground floor or basement, the fourth lowest level of the house?
Why do you need a plan of the basement? Sorry.
Why do we need a plan of the hotel? We've got 3 plans of the hotel. Your application is for a license for the pods.
I don't understand. I don't understand what you're wanting. What clarification you're wanting.
You've
Mr. Bryant.
submitted very clear plans of the top 3 floors of the hotel and a very sketchy and poor plan of the basement. I'm just wondering why. Just like to refer everybody at this point to the plans that I circulated late. I do regret circulating them late or asking Fiona to circulate them. I didn't understand. I'm sorry about the 3-day rule, but I'm glad that they were circulated. They demonstrate that there was a much clearer plan available to you to submit with this application for the basement, which you omitted to do.
And you're asking me why?
Yes.
No reason.
Okay, I'll ask you another question. Why is there an arrow indicating an exit from the basement at the front, where there is no such exit at all, actually?
That is not an arrow that is not an exit from the basement.
Well, you've just said it. You've just told us it's a plan of the basement.
No, I haven't. It's the plan of the whole. It's the plan showing the pods is the footprint of the hotel, and the steps that you see are the steps leading up into the ground floor at the front and the basement at the back.
They are shown on the plan of the ground floor, the steps leaving. You have shown on what you've told us is a plan of the basement, an exit from that point. You've deliberately put an arrow there to indicate an exit where there wasn't one.
No, I haven't.
If we look at the second sheet that was circulated the plan before you have edited it with your comments and sketchy labels, and where you've written in kitchen and dining room and indicated the toilets. That doesn't exist.
Sorry, what doesn't exist?
The arrow indicates the exit. You've deliberately written in a confusing and false representation of an exit there.
No, I haven't done any such thing.
Well, it's there for all to see.
Okay, Mr. Bryce, I think we understand that you're unclear and there's maybe some confusion around the plans and how they've been drawn. I'll give you another question, obviously, because it took a while to get started with that one. Have you got another question?
Yeah, where is the bar going to be? You said there's going to be a bar outside.
There isn't going to be a bar.
And what's happening with the room that's immediately to the left as you look at the plan of the basement, where you've written dining room? There's a room immediately to the left of that. What is that going to be used for?
It's a guest bedroom.
Well, why hasn't that been marked on the plan that you submitted? So
no,
really,
no particular reason, but we're not having a bar.
How many rooms are going to be used either for bars or restaurants in this?
We're not going to have. There isn't going to be a bar. We have a dining room.
You have 3 dining rooms.
No,
potentially.
We have one dining room.
You have a dining room on the ground floor, and you've marked on the footprint plan that you call of the basement another dining room that's on the level underneath the ground floor, and there's potentially another dining room next to that. So there's potentially 3 dining rooms in the hotel.
I think there must be some misunderstanding of the plans there, because that's not the case.
Okay, so you can assure Mr. Bryce that your intention is to have one dining room with 16 covers?
We only have one dining room, yeah.
Okay, thank you.
My point, Mr. Chairman, is that, okay, Mr. Cowton might say that's his intention at the moment, but he could change his mind at any time later and install 3 dining rooms.
Depending on any conditions that were put onto a license if it was granted.
Yes, exactly.
Okay. Right, I think what we'll do is we'll call a short break there. Actually, we'll have members' questions, then we'll draw a short break, I think, just to give everyone some time before we come back to the next half of the hearing. Councillor Melly, have you got any questions?
I do, thank you, Chair, yes. Yeah, Mr. Cowton, thank you for taking the time to explain what your plans are and how you envisage your business working. You've applied for variations of opening times and licensable hours on a couple of days, Christmas Eve and New Year's Eve. Do you mind just describing quickly how you envisage that working and what you plan to do with the premises on those dates?
We had a conversation with Mr. Golightly about Christmas Eve, and we agreed that an earlier finish time on Christmas Eve of 9 o'clock would be more appropriate.
Okay, and New Year's Eve?
New Year's Eve, we felt that with it being New Year's Eve, it would be appropriate to open a little bit later.
Okay, so your application doesn't include music, recorded music, live music, or late night refreshment. So between 11 p.m. and 1 a.m. what do you imagine, what's your intention to do with the premises at those times?
Sorry, when? What do you mean?
Well, so for example, on New Year's Eve, you won't be allowed to serve any food after 11 p.m. because you haven't applied for late night refreshment, but you're hoping to still be open.
I thought that was just an exception for New Year's Eve, but if that's the case, then we would close at 11. That wouldn't be a problem either.
Okay. So would you be happy then to, if we were to grant the license, accept a condition that alcohol is only served with food?
Yes.
Okay. I'm just trying to see if I've got any other questions. Yeah, the question was already asked about the smoking area, because you mentioned that yourself. It's something that you brought up as something you've considered as part of reducing antisocial behaviour, as having a designated smoking area.
Yeah.
So although you haven't decided exactly where it'll be yet, you've had a look at your premises and the plans for premises and seen that there is somewhere that it would be suitable for that
Yeah,
to be.
as I say, there's a plan of the outline plan which shows the footprint of the hotel and the parking spots. There's an area just by sort of in the back corner of the hotel, which I think would be suitable. I didn't want us to be pinned down at this stage until we'd finished the actual.
No, I just wanted to be sure that there is somewhere that you can have as a designated smoking
There
area.
are several
If it's something you're saying might be necessary for reducing antisocial behaviour, I wanted to be sure.
Yeah,
that it's possible.
there's plenty of spaces for a smoking area, which would be pretty private and wouldn't cause any nuisance to either residents, diners, or anybody staying in the hotel.
Okay. So have you already been operating the premises as a bed and breakfast? It has been operating as a business, yeah. But you're not aware of how many covers there are on the dining room while you've been operating it as a bed and breakfast, and you're not aware of where guests have been
I am aware.
smoking, or
I am aware of how many covers we have in the restaurant, but of course it's changed with COVID, so it depends what the context is.
okay. No, I appreciate that.
There's a maximum of 16.
Okay, but it's less than that at the moment. But of course, this is an open-ended. It doesn't have an end date to this application, so in the future it could be a maximum of 16.
Yeah,
yeah. Okay. Yeah, because there are a few things that you talked about, like in the plans that you've submitted, the greenhouses are described as temporary, and you talked about track and trace and that sort of thing, which is obviously all very important during COVID in terms of safety and keeping people safe. But obviously, this application is open-ended. It can be operated as, if it was granted, it could be operated as a premises for much longer than that. So I think it's important to understand both. Thank you. I think that's all my questions for now.
Thank you. Councillor Norman?
Hello, cheers. Yeah, so Councillor Melly's already addressed some of my questions as always, but some sort of additional, I mean, just to sort of context for this, I guess that a part of our role, I suppose, in this part is to try and ensure that some of the stuff that you've talked about that could be really positive for residents is enforceable, and is stuff that's not just nice words, as it were. So I guess kind of with regards to obviously things being served as a substantial meal, and with regards to concerns about having a bar, would a licensing condition about table service be something that you might be able to offer?
Absolutely, yeah. I mean, that's how we would like to operate it. If you sort of, just to take a different context, I sometimes used to go to the Rattle Owl. That is not the sort of place you'd go in and sit down and just have a drink. It's a restaurant. And that's how we're wanting to operate it. It would be bizarre to go in and have a drink and that's not what it is. It's not a bar.
Yeah, I appreciate it, but I hope you appreciate that part of our thing here is to make sure that that's something that is something we can have some control over. I guess to sort of sorry, go on.
The control element, if I've understood it correctly, is, could you just repeat what you would want the control element to be again?
I think let's get into those questions a little bit later. Once we've heard both sides of the argument, I think we can discuss potential conditions before we retire to consider those type of things.
Some kind of would additionally, in terms of area, I know we've had some discussion here about problems with as it stands, this is an application for a license for the whole premises. Would some sort of restriction on the area of licensing activity, like the pods and the dining room, for instance, be something that you might be?
We'd welcome that.
Okay, cool. And finally, yeah, I'm slightly bemused again about opening hours. I have to say, because there seems to be some mismatch between what you're applying for and what you're offering at this stage. So it's kind of what sort of balance are you looking for in there? The
application as first submitted was intended to give us the maximum flexibility. In terms of people's response to the application, I've made it clear that I'm perfectly happy to accept a whole host of compromises to make sure that people's fears are allayed, if you like. Does that answer your question?
Yeah, I think to an extent for now, and we'll come back in a bit. But yeah, that's all, Councillor Mason. Thank you.
Thank you. A question from me. Can you just talk me through, you've talked about food and meals. Just talk me through what you're envisaging in terms of a menu. What does your menu look like? Is it just pizza, or, talk me through what your plans are for food?
Well, it's an evolving thing as a restaurant, isn't it? And it's an ever-changing thing. But we are expecting proper meals, not just a pizza. So our concept is 3-course meals with a Mediterranean flair. So it wouldn't just be pizzas, no. We would have pasta dishes, we would have a range of salads, we will have appetizers, we'll have antipasti, we'll have desserts.
But to confirm that, I suppose the kind of business model is people are coming to you for a substantial 2-3-course meal and
eat out. We want them, we want them to stay and to enjoy the comfort of a beautiful little pod where they're safe and warm and happy.
Thank you.
And eating.
Yeah, thanks. That's everything from me. So I think, given we've had a fair showing this morning so far, nearly an hour and 20 minutes, I think we'll have a 10-minute break. So,
Chair, I'm very sorry to interrupt. Please, may I ask the applicant for a point of clarification, just to assist my understanding of the application. Mr. Cowton, just something you said when you were making your presentation. I think you said that there would be no music in the outside area, in the open area. Do I understand you to mean you're drawing a distinction between the open area and the glass pods, and that there may be music in the glass pods?
There may be music in the glass pods if a customer decides that they want to listen to a bit of music, because everybody's got portable devices these days, haven't they?
I see. So you're not. I see. So it may be that they play some music through their phone or something like that. Yeah.
It could easily be the case. Yes.
Okay. All right. Thank you. Thank you,
just
Chair.
On that point, Sandra, I could just clarify. I presume we would have no power to regulate that anyway.
Recorded and amplified music or live music, it's not regulated during the hours of up until 11 p.m. premises under capacity under 500. Yeah. I know that Leslie Cook will jump in and correct me if I am wrong on that, but that applies to licensed premises. So obviously, of course, if the premises were unlicensed, then music becomes regulated. You need a license. It's only where there's an alcohol license in place that it becomes unregulated, is my understanding. But there are other people here who will, I'm sure, correct me if I see that Mr. Trallums is already about to correct me.
So my legal colleague is quite correct, but you do have power to impose conditions, particularly if you think that there would likely to be adverse effects. So what we've heard offered by the applicant is no recorded music, no live music. He hasn't confirmed whether there'd be background music or not, but in any event, he has just confirmed that it's up to the local, anyone using the pod. So you could make it clear that in the event that you were going to grant this condition, there would be no recorded music, pre-recorded music, live music, or any background music of any type to be operated in the interests of public nuisance and promoting that licensing objective.
Did you want to come in there, Leslie? Or?
Well, if I may just say, my understanding was that because it is not regulated, we can't regulate it, and it's only on a review that we can then start to regulate it. If there are problems, then we have a review. Am I disagree?
On the back of representations, but I'll double check that in the break.
Okay. Thank you.
Thank you all.
That'd be useful.
Right, let's take us to past. So if we come back at past, what will happen? The IT colleagues will put us into separate breakout rooms, and then we'll all come back at past to have 10 minutes to refresh your mugs. Thank you, everyone, and welcome back. Just for the benefit of any of the public watching, we just had a coffee break. But during that meeting, our legal officer has had an issue raised by the licensing officer just regarding clarification around the plans for licensable activity. So Leslie Cook, if you're there, if you can just maybe outline what the concern is and how we can address it now.
Thank you, Chair. Yes, during Mr. Cowton's response to one of the questions, we discussed the plan on page 33 of the agenda, and I just require clarity of what page 33 does actually show, because Mr. Cowton made reference to the fact it was the basement, but in his answer he sort of kept changing which area this particular plan covered.
Mr. Cowton, you're on mute.
Yeah, I'm going to have to pull up page 33. So if there's anything else you need to get on with in the meantime.
No, I think this is a sticking point for us moving forward.
Okay, you'll just have to bear with me then, please.
No problem.
Chair, whilst we're waiting for Mr. Cowton to just look at that plan, just to mention for Leslie Cook's benefit, in case it's helpful, that in the agenda supplement, the additional papers submitted by Mr. Cowton, there is on page, just looking at another screen here, Chair, on page 8, there is that same plan, but with some slightly different annotations. I don't know whether that assists at all. Maybe it's the same question from the licensing officer as to, well, what is this plan? It's a slightly different version of the one, I think, on page 33 that Leslie Cook has just referred to.
Yeah, I think I'm looking at the same one with you, Sandra. I think that one just has an outline of the building, doesn't it?
Yeah, I've got that now. So I presume you're referring to the plan which shows the location of the 8 pods and then the outline of the building and the 4 parking spaces. Is that correct?
Yeah, it's the plan that's got quite a lot of writing on it and like just pods scribbled onto the back as circles in the back garden.
Scribbled?
Yeah. Like
well, sort of just drawn on by hand.
Mr. Cowton, if you have the agenda papers, it's on page 33 of the agenda papers.
I'm looking for the actual agenda papers again because I've come out of that screen. Hang on a second. I didn't print them all off.
It's the ones that when Mr. Bryce was speaking around, probably the same ones you were looking at then when you're having that conversation with Mr. Bryce.
Yeah, well, it's got written on kitchen, dining room. It's the one with regards to the question about exits. Indication.
Leslie, I know you were having technical problems earlier. I don't know whether you're able to present at all.
Oh yeah.
I'm afraid I am. I'm still having technical issues.
Okay.
I could share my screen potentially if that's would be useful.
Are you a co-host?
I don't think I am, but I could be made one.
You are a co-host, Councillor Mason. If you want me to as well, I've also got the...
Yes, I can see it now.
Oh, so you've found page 33?
Yeah, I can see it now.
Right, so can you clarify what area? It's quite clear it's the garden at the rear, but the premise element of the drawing, can you clarify what area of the premise that is? That's a terrible plan, isn't it? The dining room. Do you mean the dining room? When Mr. Bryce asked you a question, you referred to it being the basement, But then
No,
within your answer,
that is the yeah, that is the shape of that premises plan is every single floor, including the basement. But that is actually where it says the dining room and the kitchen and so on. That is the ground floor.
So that is the ground floor of the premises.
Yes, it's not
the basement.
clear, which I apologise.
So it's not the basement.
No, it's the ground floor.
Right. The reason I wanted clarity on that point, Chair, is because we wouldn't have accepted that. If that had been the basement, which we didn't think it was, we thought it was the ground floor, we wouldn't have accepted it as a suitable plan. Because we'd got clear plans of the ground floor in another plan, we accepted it as part of the application. But now that we've got clarity that it is the ground floor, I've got no further concerns.
Yeah, I don't think that. I think I submitted that plan by mistake. Actually, apologies. It's the wrong one.
So just to clarify, please, if I may, Mr. Cowton, through you, Chair, that Mr. Cowton, you have not submitted any plan of the basement, and it is not your intention to license the basement.
Correct.
Thank you.
Thank you. That's really helpful. Right, Mr. Golightly, are you with us still?
Yes, Chair.
Brilliant. It's your opportunity now to present your case as the representative of the public protection team.
Okay. Hello. Obviously, I'm Michael Golightly from City York Council Public Protection. We're making representation today on the grounds of public nuisance on the licensing application for 6 St George's Place, York. The application, as it was applied for, is for a premises that would be open from 11 o'clock in the morning till 11 o'clock at night, 7 days a week, into a quiet garden area to the rear of the hotel. This area is surrounded on 3 sides by residential gardens and dwellings. Some of these significantly overlook the proposed licensed area. The premises also sits within a highly residential area of York. It proposes 8 pods, which could hold. Now, originally I was told 8 people, but now it's 6 people, and that would be still 48 people internally inside the pods. And the external area could be used to hold more people. There is a plan to have a fireball as a visual feature, and this could attract visitors to drink outside, which may result in raised voices. The applicant initially did not offer sufficient conditions for the application to control noise from customers, other than reminding them to leave quietly. Since our representation has been made, they have offered some other conditions. However, these have either been neither formally agreed, nor have not been deemed to be, some of them have not been deemed to be sufficiently robust enough. The applicant has stated that he does not intend to have a bar outside. However, as the application stands, this would be allowed. There is therefore the risk that this could increase the flow of alcohol and therefore the amount of noise associated with customers. This links into the fact that the hotel is in close proximity to the racecourse. There's still a bit of confusion even today over this as to who's going to be using the pods. Once the external area is licensed, it could be open to customers from the racecourse. The applicant said that it's going to be for bookings for meals. However, has also said that there'll be residents and non-residents there. Therefore, this could allow people from the racecourse to come there, and you would need some quite stringent conditions on to prevent antisocial behaviour if that's happening, or curtail the hours. In terms of the pods, noise tests have been carried out by the applicant. However, he's done that himself. It hasn't been carried out by a qualified acoustician. It's been done on a phone app. There's no way of knowing if the phone app has been calibrated in a laboratory. I'm sure it hasn't. There's no account for drift. There's no details that we'd need to see, such as background noise levels inside the pods, reverberation times pods, background levels outside the pods over a specified time period, what the difference between the 2 noise levels are, what noise is being used, what standardized level has been used for the noise internally to see what the breakout is. Basically, there's no information about the sound attenuation of the pods, nor the accumulative impact of these being used at the same time. The applicant has agreed to restricting the hours of the outside area on Christmas Eve to between 11 o'clock in the morning and 9 o'clock in the evening, and that is welcomed. However, we have not been able to agree finish times for the normal operating days. In summary, as it stands, There's some confusion as to what the applicant wants to do with in terms of who's going to be attending the pods. There's no information about the sound insulation properties of the pods, and we have concerns about the ability of noise to be controlled in the premises due to its location, which is close to residential gardens and dwellings. Insufficient conditions have been submitted in order to control noise from the licensable activities, and without stringent conditions being attached or the hours being curtailed for the use of the outside area, public protection have concerns. We are therefore making representation on the grounds of public nuisance and would advise the committee to refuse the application unless these concerns can be resolved.
Thank you. Right, there's now opportunity for people to ask questions of Mr. Golightly. First one, Mr. Cowton, have you got any questions of Mr. Golightly?
Yes, thank you, Michael. You say the conditions are not robust enough. If I can just answer that point, we think that
this is a time for you to ask questions of Mr. Golightly. You'll get a chance at the end to summarise your case, but this is just a chance for you. For example, if you had a question about a condition, you could have asked that, but it's going to be a question, I'm afraid.
Okay, sorry. What is the issue in your view, Mr. Golightly, about racegoers booking a pod?
Yeah, okay, so you've stated that basically it's about controlling the noise on those particular days. Normally, where you're going to have premises whereby it's likely that people are going to come down, you would have door staff on to control antisocial behaviour. There's a massive increase of antisocial behaviour around those days and concerns, especially as this would be introducing a licensing area into a highly residential area. I think if you're going to have it for customers and guests, that's one way. So a customer books it for other guests who are staying there. That's already reducing the amount. If you have a customer who then books it out, or two customers who book out 2 pods, for example, with more people coming who are coming to the race course, then you've got to look at and consider the noise impact of that. If the premises is open on race days before the races take place, for example, therefore they're less likely to be in drink. If they're then coming back from the race course in drink, more likely to have raised voices, and you've got people who are coming, it's just increased that risk that we've got really from the antisocial behaviour and the noise that could be generated because of that. I think on normal nights and days that might be very different, but certainly on race days, there's an increased likelihood that that's going to bring noise which doesn't exist there already into the area. And it's how you're going to control that and how you're going to manage that once that happens, if that is what does happen. So that's where the concern comes from.
Do you not think that our limitation of the groups to 6 and the requirement to pre-book, along with the serving of alcohol only with food orders, do you not think that would sufficiently mitigate that risk?
Not sufficiently. It is going in the right direction. For example, by having it that somebody books it and having the waitress service, etc., those kind of things will all help. As it stands, you need to be more precise about who's going to book the premises, who are they going to allow in. Is it going to be one person who books it, who's staying there as a guest, and therefore they then invite another 5 people in from the race to come in? How are you going to understand who's coming in there? How are you going to control that? Are you going to have a refusals policy? Are you going to have a noise management plan policy? There's not enough there for us to have mitigated it. Things have been offered, you're right. I just think there's just not enough there. It needs to be quite stringent and quite carefully worded. Otherwise, there are loopholes there, and it's how do you control that? I think really on the race days, particularly, you could be having people coming in who are in drink, who are louder and have more raised voices. If they're inside the pubs eating, that's one thing. There's going to be benches outside as well, and that was in your initial application. Therefore, and if you're licensing the whole of that outside area, people can drink in that outside area. How are you going to control those people? How are you going to control them from going out there to drink around the fire pit? You're going to have the fire pit, but not have people sitting around and not using those benches that were originally proposed. How many people are you going to have from the hotel coming out to mix with these? It's how you are creating an area in a highly residential area where you are going to have people in high spirits, in drink, therefore into that area, and in excess of 48 people inside the pods. Once the external area is licensed, potentially more, so 48 would be 6 people per pod. So you are going to have that many people in that area that aren't currently there. And how do you control that? That's the question, is how do you, and so far we've got a condition that's been sent in, and we will ask people to leave quietly. There just isn't sufficient there for us to say that this is okay at the moment.
Thank you. Mr. Charlambides, do you have any questions of Mr. Golightly?
Sir, absolutely. Just a few, Mr. Golightly. Firstly, in terms of this operating model of an outdoor food and drink led area in a back garden on a residential cul-de-sac entirely surrounded by residential properties, do you have any such premises in York that you can draw experience on?
Trying to think for you. Doesn't come to mind. No, because it doesn't come to mind, because normally there's some kind of buffer. I looked at somewhere which was similar, but there was still a big buffer between residential premises. I'm trying to think if anywhere would have that. Not unless they've historically already been there. I think there's 1 or 2 pubs that historically have beer gardens there, but not that I can think of.
No. Are there any licensed premises in the near or surrounding area?
2 seconds. I'm just going to pull up a map.
Thank you.
With the technology, this may take a bit of time.
If I can come in, I think the Elmbank Hotel is probably the closest licensed premise.
Yeah, that's what I think too.
Yeah, people may know better. Certainly, from looking at the plans that initially that I looked at, there's a lot of residential around there. In fact, the applicant has already stated that as well.
He has. In fact, it's an exclusively residential area. One of the wonders of technology is that I've just had a photograph from a child's bedroom window, which directly overlooks the smoking area. From a public protection point of view, situating a smoking area that is underneath a child's bedroom, what's your views on that?
It would be badly managed. What you want to do is move the smoking area away from there. You need to take this into consideration. From a public protection perspective, it wouldn't be about the smoke itself, but it would be about the noise from people who are there, especially as it goes later into the night, 10 o'clock, 9 o'clock. You've got to assume that a child would be going to bed earlier than an adult, for example.
Right. And obviously, it's not just children that need their sleep. Adults need their sleep. And from a public protection point of view, disturbed sleep is a relevant factor. Isn't that right?
Yes, it is. Yes. So if you have disturbed sleep, then that can affect your health, and obviously also how you cognitively think. So it would be something we'd consider. We could consider it through the Environmental Protection Act, but we'd look to see whether it's a statutory nuisance. But certainly it should be managed out of any kind of place that you're going to have as a premises license.
And it's not just noise, given that all the bedrooms back onto their gardens, as is natural. There's the issue of light as well, isn't there? That's just as intrusive as noise.
Light, it would be introducing light into a dark area. However, I think that under the Environmental Protection Act, the light, it could be controlled, in all honesty. I think that could be controlled. You can angle it down, you can angle it away. If it's going to shine out from the pods, this might be intrusive. You need to know what the levels of that are going to be. But the guidance would be that the actual people who are perceiving the light would have to put curtains up in order just to close it. So it comes upon the person who's receiving the light, actually. Light wouldn't be so much of an issue to us.
But it's a relevant factor in terms of providing a management plan in respect of light.
Yes, obviously. I mean, if you're going to plan to do something, you're going to have to consider the impact of that. You think somebody would consider the impact of that. Same with the smoking area, really. It's about having a plan for what you want to do and how you're going to make that work in an area.
And the other thing, of course, is also food smells. Outdoor pizza ovens, 3-course meals. Given that the kitchen is situated towards the back, what you would effectively have is the introduction of commercial kitchen, introducing food smells into that residential area.
Absolutely, yeah, that can be a statutory nuisance. So if that's really close, even in the garden, that could affect somebody. Depends what they're cooking. We need to know what they're cooking, what the facilities they're going to put on there to try to mitigate the odour. Where that's going to be as well, because it's not on the plan as to where that's actually going to be that I can see. Yes, that would be a consideration.
No, well, we've heard the plans are terrible, so that's a concession that's been wonderfully made by Mr. Cowton, and I'll come back to plans later. And when we're talking about noise and disturbance and so on, when we're thinking about noise, one of the key factors that the Section 182 guidance tells us to think about is also what is said within that noise. So, for example, adult conversation, adult expletives, and the potential for those are just as relevant, aren't they? Are they not, in the context of public protection and the licensing regime?
Yeah, potentially for the protection of children, actually, which we didn't object about. But certainly from the noise perspective, as soon as you've got one person shouting, that can be loud. And then in reference to the background noise levels, that would be a constant. Whereas when people are talking in raised voices, this is more perceptible because there's an undulation in the sound. And as to the language, yes, again, it's a consideration because it would be bringing adult noise into an area near a child.
And one thing you can help clarify, I'm really surprised to read in Mr. Cowton's representations and his submissions today, refuse is collected once a month. Is that right? How does that work? Do you have the rubbish piling outside and it's collected only once a month? Or do you have to have special arrangements if you're a commercial restaurant and bar to arrange for, collection of well, glasses and food and everything else?
Yeah, I mean, in terms of getting things, I think in the licensing respect, it's not a licensable activity, therefore we wouldn't comment on it. However, yeah, you would expect that commercial waste is different to domestic waste, therefore it needs to be got rid of in an appropriate manner and needs to be arranged for. And yeah, I think from a licensing perspective, we wouldn't consider that.
Well, I'd submit you should, because obviously it flows from the consequences of that. So if you've got bottles and cans racking up and so on, and then you've got which attracts vermin and things like that, then it is relevant. So it's a mistake to say that your refuse collection is only once a month.
I'm not sure. I don't deal with that. So, but however, so I can't really comment on that because simply because I don't deal with the refuse collections and how many times they take place. It should be in the plan. Basically it should be planned for in any kind of business as to how many times, what you're going to have, and how much waste you're going to remove at each time. I'm afraid I can't answer that because it's beyond my remit. Sorry.
My final question, just looking at this place as a B&B, and given the huge explosion of Airbnb and so on, do you have any experience of the impact of bed and breakfast operations in residential areas? Do they provide a positive benefit, or what happens with the garden and the front areas, for example, for those who are weekending and might not have any care or connection to their local community?
Yeah, that's very pertinent, because if it's a hotel, you're going to have somebody there all the time, maintaining it and looking at it. With Airbnb and any kind of bed and breakfast place, there is a possibility you're going to have people there on stag do's and hen do's and parties who are going to use that area, maybe in high spirit. Certainly, we are seeing an increase in York to complaints about Airbnb hotels, or hotels which have opened up, which were flats in residential areas. It is probably the most significant impact, yes.
And this effect then would be to exacerbate this impact that already exists.
It would certainly introduce it into this area. So you've got a highly residential area at the moment where there is no other licensed activities taking place or premises taken there to run, and suddenly you're introducing this noise to that area. So I think it would have a significant impact if not well managed.
Thank you. Thank you very much.
Thank you. Mr. Bryce, any questions of Mr. Golightly? You're on mute.
Yes, I do have a question for Mr. Golightly. I notice in your representation, everything is a reference to the outside area, garden areas, external areas. It's all that. There's no mention of what about inside adjacent buildings. Are you aware that the premises number 6 St George's Place share a party wall with 8 rooms in the adjacent house at number 4? It's not a detached building, which has been inferred from these plans in an earlier application.
I think when you're looking at that, I think from a license perspective, with there being no regulated entertainment or music requested, we wouldn't comment on that. We wouldn't have had a concern about that.
Well, there would be potentially people drinking the other side of very thin Victorian built walls. The Victorians were not very good at soundproofing. There would be holiday makers, potentially foreign international students. I mean, imagine trying to do a dissertation with a bar through the other side of the wall and the general hum coming through.
Yeah, there is a possibility for that to be an issue.
I understand now that we've clarified the plan about the basement, that is not to be licensed under this application.
I think there you come down to what needs to be clarified here today, which is which area of the hotel is going to be licensed. That's quite specific as to what you do. Do you want all the bedrooms licensed? Do you want all the rooms licensed? Do you want certain areas licensed? That needs to be clarified to limit the amount of noise
I did ask the licensing officer at the beginning of the hearing that the entire premises would be licensed and usable for the consumption of alcohol and sale of alcohol.
Yeah, so there is a risk. There is a risk. We haven't considered it in this. We've considered the outside area, but we
don't those people deserve any consideration like everyone else in the neighbourhood who live in other houses, separate dwellings outside and not sharing a party wall?
No, absolutely do. I mean, we would normally look at a license application and look to see what the impact and likely impact is going to be.
Well, this seems to be saying that they should not be considered. I'm sorry, that's just not acceptable.
Okay, I'm not saying that. I'm just saying we in our representation we were looking at the outside area. You've asked me whether there is a risk to that. I've said yes, obviously there is a risk to that, and that needs to be clarified as to which points are going to be which areas of the hotel are going to be licensed and non-licensed.
Okay, thank you.
Thank you.
Thanks. Councillor Millie, any questions?
Yes, thank you, Chair. There are a few issues that you raised just now in your representation and also in your report provided as with the reports to us today. And in summation, you've said there are insufficient conditions to control noise, etc., etc. So it just says you're making representation on the grounds of public nuisance, but it's not clear whether you're in favour of complete refusal or whether you feel that there are conditions that could be placed that would make it an acceptable application. So, for example, just now you highlighted race days, for example. Are there conditions that could be put in place that would make it acceptable in your view on race days, or is there nothing that could be done to mitigate the harm or prevent the harm?
I think it could mitigate the noise issues if it was significantly change the application, as it were, and what's being proposed here. You're looking at the numbers of the pods, you're looking at the area that's being licensed, you looked at where activities are going to take place. That there is a risk that it will introduce noise into the area where there isn't noise at the moment, and that can't be mitigated for. That's also the issue with the pods. Normally, we would look at an application and assume that planning permission is being granted. Therefore, those issues would have been dealt with already, so we'd have known what attenuation was through the pods. So it does make it difficult to agree conditions on something you're not sure whether that's going to actually be an effective condition or not. From looking at it, if the hours were restricted, if it's clarified who's going to use the pods, and it was significantly curtailed in terms of hours and the use and the amount and the space, with more stringent conditions, it is possible that we may agree that, because no music has been proposed up until today, when it said it's going to have some music inside the pods as well, potentially. So yeah, it's a bit, we didn't really have time to discuss with it coming in over Christmas any conditions. A little bit of mediation was managed. I would say that if it's curtailed in the hours significantly, the amount of space and use and what the applicant wants to actually do in there, and we can clarify that and people are in agreement with that, then there are some conditions that they may be able to attach. There is also that question on the pods, you know, are they going to attenuate sound? How many people are you going to have there? It's a bit of a grey area. Does that answer you? Sorry.
Yes, I think so. I mean, do you have any specifics in terms of hours? I know you did already negotiate. So I'm just find a report. You did already negotiate, I think, some proposed terms to changes of hours.
Yeah, when we looked at other sites. So yeah.
I was going to say, in terms of recorded music and that sort of thing, it's not licensable until 11 p.m.
Correct.
Anyway. Is that the sort of hours that you had in mind, or were you thinking it needed to be earlier than that because of the residential nature of the area?
A lot earlier, yeah. I mean, you're looking at 9 p.m. normal days, I would say, or Sundays you might want to do slightly earlier. Certainly on race days, you want to restrict it down to before the race events are already taking place, or about 2 o'clock in the afternoon, just to stop that potential for people coming back in drink. But I would say, yeah, about 9 o'clock. I think I'm okay for New Year's Eve, but Christmas Eve, again, bring that down to 9 p.m. So that would curtail it down to about 9 p.m. That would be in keeping with other premises. However, you've then got the number of pods. That would be a significant number of people more than we'd have in other licensed premises where it's close to residential. This is a significant amount more people. How are you going to control that noise? And again, as has been mentioned, in what is a significantly in residential area, I'm more so erring on the side of being cautionary with this as to whether it's a suitable premises.
Okay, so you feel that on race days, for example, just the one we keep coming back to, there's no conditions that could be in place that could make it acceptable from a public protection point of view late after the race are finished. For example, a capped capacity enforced by door staff, alcohol only served with food, that sort of thing.
I think that would be difficult. I think you'd have to have somebody on site there. You'd have to have a reduced capacity of people. Even bearing in mind that one person shouting can be significantly audible. Once you've got 10, 20, 30 people in a rear garden area, that could be really audible. I think it becomes difficult. Then you're looking at door staff, and having to have door staff on is quite a big imposition, because what do you do if things do get out of control? I think in the afternoons on the race days, it creates a significant risk.
Okay, thank you. And my final question is about, because the commercial kitchen was mentioned, I can't remember who by, but somebody said that it would be introducing a commercial kitchen. But is it already operating as a commercial kitchen at breakfast time? Would there be a new issue here with these licensable activities in terms of smells introduced by a commercial kitchen by the hours being extended that the commercial kitchen are in use, by changing it from just bed and breakfast to restaurant as well?
I think it's the location it's going to be. If you're going to have a pizzeria outside, you're going to be introducing smoke and odours directly next to neighbours. I think that is a bit of a risk. The smoke element of it can be controlled under the Clean Air Act. However, the odours from the food being cooked, yes, you're going to be removing that from a kitchen with a chimney also already inside the building into the garden area directly adjacent to residents. They can then complain about those odours, and you are introducing those smells there. And whether the smells are nice or not, it potentially could be unwanted, and it does create a risk.
So this application doesn't include late night refreshment, so there wouldn't be food at any time that it's a licensable activity anyway. So is this maybe a discussion for planning if there's a change of use application? Because if this application was refused and there was no alcohol, they presumably could still have a pizza oven in the garden or in the kitchen or in the basement or.
Absolutely, yeah. This is the crux of it, really. It should have gone for planning first, because that then irons out a lot of our concerns, really. I mean, that's why we're looking at really the noise from the customers in the area and the size of it and the size of what he's proposing. Because yeah, under the planning regime, we'd have looked at the noise outbreak from the glass pods. We'd have looked at the cooking facilities. That goes under a different part of what we would look at in the application. So yeah, I think mostly it's our concern is about the noise from people into the rear area where there's lots of residential. That's the main crux of our concern with the license of this. You are introducing a licensed area into that residential area, and how do you control that? How do you put something in place that is sufficient to stop noise? You can have a noise management plan, but then is anything you're going to do going to work to stop that noise from affecting people nearby, especially as it goes later in the evenings from 9 o'clock onwards? But the pizza aspect of it and the cooking aspect of it, it would introduce smoke, odors. But yeah, that could be looked at under the Environmental Protection Act or under planning.
Sorry, I said that was my last question, but I've just thought of another one. So I believe this has currently been operating as a bed and breakfast, not necessarily staffed, maybe more of the kind of Airbnb style business operating model. So currently, or as this premises may continue to operate if this license wasn't granted, are people able to drink in rooms anyway if they've bought them at another licensed premises and off license and brought alcohol back? They can drink in the rooms. Have there been any noise complaints or anything relating to drinking in the bedrooms and noise into neighbouring properties and that sort of thing that you're aware of?
Yeah, no, good question. No, we haven't had any complaints.
But in your view, this could possibly increase the chance of noise levels rising or increase the likelihood of complaints in the future, or do you have a view?
No, I said earlier on to the earlier question that yeah, it's something to consider, the risk that you're going to have a whole place. I mean, the thing is, you're going to have a whole premises licensed. Once you have a whole premises licensed, you could then introduce bars into each room or into each area. Therefore, it could see a significant growth inside that premises. If it maintains as it is currently, where there's no license inside and it's just for the external area, therefore the risk inside would be people could bring it in and bring the drinks in, so there is a slight increase in risk. However, that's why we're not really concerned too much about the inside of the premises. But yeah, this application, if it could significantly change even the inside, you could end up having a bar inside once it's licensed, and therefore have more numbers internally as well. So it could increase the risk, but we haven't really focused on that in our representations.
Okay, so kind of the application as it stands in terms of the whole premises being licensed, you don't have any particular concerns about that, meaning that in the future there could, what do they call it in hotels, like a kind of mini bar, like a little fridge where you can buy wine and beer and that sort of thing?
Yeah, you could introduce that, but you could also just have a bar anywhere inside the hotel. You'd be making a licensed area of the whole area, and yeah, there is a slight risk of that. I'm not sure if I'm making myself clear on this one. Our major concerns about the outside area and the noise from that. Internally, yeah, if they have a fridge, how much more is it going to be to another hotel, really?
Oh, no, thank you. That is clear. Thanks very much.
Thank you.
Thank you. Councillor Norman.
Yeah, cheers. Only a few. I think we've covered quite a lot, haven't we? I guess just kind of for clarity, really, again, obviously there is stuff that could be done to mitigate problems. I hear that with regards to, restricting licensed areas, timings, etc., etc. Would it be fair to say, from what you're telling us, that there are other things like potential sound leakage from the rooms, from the pods and stuff like that, that it would be impossible for us to mediate at this hearing because there's not sufficient evidence and information provided and supplied to
Correct.
tell whether or not that would be a problem?
Yeah, I mean, you say, okay, we're going to put in a noise management plan, but then we find out that there's no sound attenuation that's sufficient from the pods once everybody's in there and they've got the music playing and they're all used at the same time. Therefore, that negates any condition that we put on there because the condition then is unachievable.
Okay, there. No, thank you. That makes it very clear. Thank you.
Thank you. I've got no questions, Mr. Golightly, so thank you for your time. I'm looking at the clock and we've nearly been going an hour, conscious that Mr. Shalambides will probably have half an hour plus questions. So that would take us, well over an hour and a half. I suggest we just have a short 5-minute break, or we come back for past, and then it'll be Mr. Shalambides' time to present his case on behalf of the residents he's representing. Brilliant. So again, we follow the instructions of the IT people. They'll take us to a waiting room, and we'll see you all back at 12:30. Right, thank you, and welcome back, everyone. And again, just for the benefit of anyone that might be watching, we're just halfway through this licensing hearing, or maybe a little bit more than that. And now I'm going to ask Mr. Sharolan Bedes, who's the barrister representing a fair amount of the residents, to present the case on behalf of those residents. So, Mr. Sharolan Bedes, I'll give you half an hour. If you feel like you need a bit more time at that point, just let me know.
So thank you very much, and thank you to all the local residents for their instructions, and also for taking the time to meet with me over 2 Zoom meetings in the evenings, and the emails they've sent and the information that they've sent, and also our local ward councillors, one of whom was able to join us today to answer any questions that we, or you specifically, sir, might have. So it's really important to focus on exactly is being asked for here. There's no dispute that this is an entirely residential area. The closest premises at some distance away is operated as a hotel. The specific locality is an entirely residential cul-de-sac. Even the existing operation of the premises as a bed and breakfast is geared towards just that use, effectively residential use on a temporary basis. And what you're being asked to authorise by way of the licensing regime is essentially an outdoor food and drink led development that will operate in a hitherto darkened garden. So just imagine this for a moment. In a residential area, someone wants to stick a restaurant with food in it, which will have a minimum of 48 people, plus a number of staff that we don't know, plus the residents for what currently exists as 10 bedrooms, but we know there are a further 4 bedrooms being developed in the basement. I don't know where the planning is with that, plus whatever guests they might have, plus whatever use in the smoking area. So potentially a significant number of people that will be in this outdoor area at any one time. Some of them using these pods, some of them not using the pods, some of them congregating outside. So what you want is to consult your own experience. And Mr. Golightly was very helpful in this when I asked him, can you give me an example of a restaurant that is opening up to be food-led, entirely surrounded by residential premises in this type of location? We're not talking about York City Centre. We are talking about an exclusive residential area in an exclusively residential cul-de-sac, and he could not, and I'd ask you to as well. Licensing and planning are separate regimes, but what is interesting here is that in the absence of any information, you are effectively being asked, is it permissible for a rear garden of a residential premises used as a bed and breakfast to be used as a restaurant and or bar in some capacity? Now that question, and the correct answer to that question, is actually about land use, it's about planning. And as your own statement of licensing policy says, albeit that these are separate regimes, you expect applicants to have planning permission in place. And indeed the importance of that advice, I don't know if Mr. Cowton has read it or whether he's chosen to ignore it or just not understood it, but the importance of that advice is demonstrated by your public protection officer who says, I just don't have the information. I can't make that assessment. And if one of your experts under the regime can't make that assessment, you as experienced lay members can't make that assessment. And in fact, it's an assessment that needs to be made by planning. And so just on that very basis alone, you ought to say, look, I don't have enough information, please go away and get things in order. You know, sort out your planning, sort out your building, sort out your vents and all these questions that bear relevance. And of course, if planning says, absolutely, we think it's a really, really good idea to put a late night restaurant with bar in the back garden, surrounded by other back gardens, overlooked by families and children's, and the City of York Planning Department thinks that's a good idea, then you in licensing can deal with that accordingly. I would be very surprised. The other thing to bear in mind about licensing is that there's this idea that licensing is there to serve commercial premises, particularly during COVID. We keep being told this is about a COVID response. This is not about a COVID response. This is about the long-term investment into an unauthorized, as a matter of planning use, restaurant and bar in a garden surrounded by other gardens. We're all very sympathetic to the COVID impacts, whether we're a self-employed person living alone at home, or we have a family and we're living at home, and so on. But COVID is not an excuse to allow for unregulated, uncontrolled operations just as you want them. If this was a genuine COVID response, you'd have expected it to be time limited, for example. But as you and your colleagues are aware, the Section 182 guidance makes it clear that the licensing regime is about the public interest. Paragraph 1.5 tells you that your key aims and purposes that are vitally important and our principal aims for you include protecting the public and local residents from antisocial behaviour and noise nuisance caused by irresponsible licensed premises. I don't think you can get a more irresponsible, ill-thought application than this, and I'll go through that in due course. So first bullet point says, protect the local residents and the local community from such irresponsible applications. The final two bullet points talk about providing a regulatory framework for alcohol, which reflects the needs of local communities and empowers local communities to make and enforce decisions about the most appropriate licensing strategies for their local areas. Well, what does that mean? It means that when you get an application in an exclusively residential area, in an exclusive residential cul-de-sac that proposes to situate a restaurant and bar in the middle of a garden surrounded by gardens, which are all residentially used, which are used by families with children, when that local community gets together and takes the time, firstly, to make representations in great detail according to the parameters set out by the Licensing Act. They've actually have read the Section 182 guidance and your statement of licensing policy and have focused their representations. When they then take time to hire a specialist licensing barrister to advise them and pay for that, when they take time to have a number of Zoom meetings with their consultant, with themselves, when they organize themselves in order to say, well, you lot are going to watch this on YouTube, you will be available to answer questions, we're all going to take time out of our day in order to oppose this. And then I'm grateful to both the ward councillors that were at our meeting last Wednesday, but we agreed that only one of them would return back. And then our own ward councillor supports us by taking his time to represent and be here to answer any questions. The local community is making a very clear statement about the strategy it expects of its locally elected democratic officials that are there to answer to our interests and the decision that they are to make. And the decision we're going to urge on you is to say no. And in fact, the final bullet point at 1.5 says to encourage greater community involvement in licensing decisions and give local residents the opportunity to have their say regarding licensing decisions that may affect them. Well, we're having our say, we're setting out our strategy for the local area, and sir, to be somewhat blunt, we do expect you to listen to us because this is the point of licensing. It's about you, our elected members, taking on board our interest. And that's made clear at paragraph 9.38 of the Section 182 guidance, which I'm sure you're familiar with, which states that when making a decision such as this, let me make sure I quote it correctly, the licensing authority must promote the licensing interests in the overall interests of the local community. To be perfectly blunt, the commercial interests and whatever Mr. Cowton may imagine or dream of when he's sketching these things out are not relevant. And indeed, you'll be familiar in the context of reviews, you're again reminded that you're making decisions in the interest of the wider community and not those of the individual license holder. And I've said that I think this is a really irresponsible application, and it can be demonstrated by the plans. Now, the plans, you don't need me or my rhetoric to describe the value of those plans. They've clearly confused all of us. They've even confused the applicant. But in respect of the plan at page 33, you will see that the applicant has described it as a terrible plan it's a mistake. That's just not good enough. This is the man that wants to operate a restaurant and bar until 11 o'clock with, by my calculations, the potential to have in excess of 80 people at any one time when you include staff and residents, and he makes a mistake as to one of the plans. You'll know that submitting a plan is fundamental to the licensing exercise. They must be clear and legible in all material respects. Now, that doesn't mean you've got to get it done by a professional, but let's make it work. So to confuse the basement with the ground floor, to fail to identify the areas of licensable activity, to fail to identify the dining room, both internal and external, to fail to provide what you'll be familiar with, the dotted line of alcohol activities, highlight areas of storage, highlight areas of servery. These are basic responsibilities that tell us how the plan is going to operate. We have been forced to ask questions of the applicant to detail his plan, and we still don't have a satisfactory answer. In fact, it would be quite appropriate for you to dismiss the plan on the basis that there's no licensable areas, no storage, no servery, no smoking area, no clear description of the dining room, the amount of covers, the likely future progress, and the fact that this plan and this application is so open-ended, he could potentially change any number of the bedrooms into dining areas or bar areas, and you've heard that from your public protection officer. I was absolutely chilled that when you, sir, asked, tell me about the food and the meals, the response of Mr. Cowton was, well, it's an evolving thing and an ever-changing thing. And that is quite chilling. He doesn't know what he's going to do. It's in effect that he's kind of gambled on some premises license, and then he will use it any which way he will. And certainly as far as the residents are concerned, what he does is on his own basis, goes in, pours concrete, starts erecting permanent additions, develops the basement, and then as an afterthought, seeks to get permission, as an afterthought, seeks to engage with the council, as an afterthought at the 11th hour, seems to engage in these negotiations with your environmental health officer, who himself says, I don't know, I don't have enough information. And the danger of that is demonstrated by the fact that the local police responsible authorities have agreed conditions. I'm shocked by that. We wrote to the police and asked them to attend today. They are unfortunately busy and couldn't attend. They did invite me to ask them questions in a schedule that they would answer. I declined to do so because it wouldn't be fair upon Mr. Cowton to do that and for me to try and submit it into evidence. But your own environmental health officer is clear in saying, I don't know, I can't assess that. I don't know, I don't have the information. Now, that is staggering because both your own statement of licensing policy and the section 182 guidance at paragraph 8.41 onwards make it clear that applicants are expected, that's the word they use, are expected to undertake their own inquiries about the area in which their premises are situated to inform the content of the application. Applicants in particular, I quote from paragraph 8.42, are expected to obtain sufficient information to enable them to demonstrate, when setting out the steps they propose to take to tackle the licensing objectives, layout of the local area. Well, he can't even get a plan of his own backyard organised, let alone the local area, physical environment, proximity to residential premises, and proximity where children may congregate, or indeed where children may sleep. There is a child's bedroom overlooking the proposed smoking area. Such is the poverty of his risk assessment and of his local inquiries. And the fact that even though this gentleman is isolating at home, and I have every sympathy with that, I'm going through it myself, the fact that he can nonetheless arrange plans, builders, acoustic tests, pouring concrete, an email or a letter drop through a friend to some of your neighbours to find out about the particular characteristics of this area would have been the least that we can do. the guidance says that any risk proposed to the local area. Well, I was aided by the fact that some of the residents sent me a video. This is a dark area with poor street lighting, appropriate for the residential area that it is. When you look at the back gardens at night, they are exclusively dark. The risks about light, the risk about food smells. We don't know if it's going to be pizza to a 3-course meal or to what. The risks associated with vents, deliveries, people loitering, the impact of racegoers, the fact that I could just book in and say I'm coming down for a weekend without declaring that I'm having a stag or not, as the case may be, the risk of how many people congregate. And none of this has been taken into account. And what was of grave concern to me is that in response to my questions and in response to your questions and your colleagues, he clearly hadn't thought about this, because it's an ever-evolving thing and an ever-changing thing. Just observe in respect of food. You know, as an experienced panel, that if you want to be a food-led venue, the condition you offer is that alcohol will only be served as part of a table meal to seated customers by table service and as part of a substantial table meal. That is the standard, usual, expected wording. Mr. Cowton is not familiar with this at all, which demonstrates his lack of experience and lack of knowledge. He is not only gambling on getting this license and doing whatever he can with it, he is gambling with his experience and the impact that it will have on the local residents. There are 9 paragraphs in terms of the risk assessment that he's unfamiliar with, which sets out how he should go about this. The Court of Appeal reminds you in Hope and Glory at paragraph 42 that it's all about location. Is this suitable for this particular location? And what we are left to do is we've been left through my questions, through Mr. Bryce's questions, from the questions of your public protection officer and yourself to try and work out what Mr. Cowton is going to do. It's not for you and your colleagues to sit down and assess where should the smoking area go? What are the terminal hours? I mean, just the Councillor Melly's very relevant question about late night refreshment, which took Mr. Cowton completely by surprise, that after 11 o'clock, you do not need to serve, you need a late night refreshment permission in order to serve hot food and drink. So the condition of selling alcohol with a substantial meal goes away. Even his New Year's party will be such that he would be forced to tell anyone using the pods, well, you can't have any drink because food is now finished. He hasn't even thought about the basic tenets of licensing in that context. And again, that should cause grave concern and invite you to entirely reject the application. Now, I know you'll have read the statements that have been prepared by the local residents, but just observe very closely in respect of briefly the licensing objectives. Crime and disorder, we already know about the December break-in. We know about the effects of disorder doesn't need to lead to criminal offences. It can be noise, it can be shouting, it can be expletives, it can be difficult customers refusing to leave. Safety issues will vary, but of course they will be affected and they can be responded to by CCTV. One of the things that has not been considered in the context of CCTV is you've got this outdoor area with these glass pods surrounded by local residents. How are you going to ensure that data protection is preserved and privacy is preserved? I've not heard anything about that, and I doubt I will. We know about the particular vulnerabilities insofar as children are concerned. Now, the level of protecting children from harm is incredibly low. We know from paragraph 222 of the section 182 guidance that says it protects their moral, psychological and physical harm. And one of examples that they give you is protecting children from being able to hear expletives. So that tells you how low it is. And you know, as experienced licensing counsellors, that morality, psychological issues are things you normally don't take into account. But can you imagine a restaurant in this way. Now, I'm not suggesting that everyone who might get drunk or engage in antisocial behaviour will be loud and obnoxious. But let's say you've won at the races and you're on the phone to your mate. It's like, I fucking won. I fucking love you. Imagine having to explain that to the 6-year-old whose bedroom overlooks the smoking area. What do they do about that? Or the family whose dining area overlooks the dining pods that they can see into, and vice versa. Because the fact is, this land is on a gradient, so we can see into it. It's another factor that's not been taken into account that would have been done in planning. The children are going to be exposed to expletives, smells, noise, light late at night, which hasn't been assessed, and even when they're playing in their own garden. Just think about that. If you've got kids and they want to play cricket and you know you're living next door to someone literally with glass houses, 8 of them in their back garden, don't play, don't do that, don't kick the ball. We're also limiting the amenity and enjoyment of kids in their own back garden. If you grant this license, what you are saying is that this bed and breakfast to open up a restaurant and bar in its garden is more important than the families in this residential area being able to enjoy their garden to the fullest extent. You will effectively be saying to the children that live around there, no ball games because of this premises. We know about public nuisance. It's been discussed a great deal, but it covers everything from parking. If you look at the map at Appendix 7, you'll see that the proposal is that the proposed guests will be told, go park across Mount Vale down to the free parking Knavesmire Road. Now, I don't know about you, but I'm quite lazy. If it's raining, I want to park as close as I can to the restaurant in order that I can get in. I don't care about the residents. I'm only going to be there for a night or two or a weekend or two. My behaviour doesn't really matter to me. A polite notice means no more than that, because when it's a question of me getting wet or getting close to the restaurant, I will go there first. So again, it just demonstrates that it's an ill-thought plan. This is a cul-de-sac. It will mean that cars are parking or taxis are dropping people off. There's no roundabout, so it's 3-point turns in a residential area already under stress. It will mean people are coming and going. They'll be greeting people. There'll be people waiting at the front to get to their table and pod. We haven't heard about how or where these parties are going to be organised. There's no reception in the plan. So just think about this for a minute. One of the things that Mr. Cowton has completely failed to even think about is, where does he receive all these parties? Where do they wait? What if they all book for table at night at 7 o'clock? Are you going to keep them in the front? Are you going to keep them in the car park under the 6-year-old bedroom? Where in this house are you going to keep them? Again, fail to think about that. You could potentially have bottlenecks of people all waiting to be seated, and let's assume that they're not all patient and kindly, talking loudly on their phones, waiting to be seated. I'm pleased to see Mr. Cowton's making a note, because he's been making notes throughout, quite rightly, because we're the ones that are telling him what he should have thought of in the first place. And that's before you even get people in. I don't know where the outdoor pizza is going to be located, where the servery is, or how the staff are going to be moving backwards and forwards. I don't know where the doors are going to be, where the noise is going to be emanating, how orders are going to be had. I don't know if they're going to use polycarbonates or glass, how that's going to be taken care of. So the reality is that just on, I think I'm running out of time, but just on those few examples, and there are many, many more located in my evidence that have been provided by the all the local residents from the local community, this is entirely unsuitable a location for this type of commercial enterprise that is being imagined as things evolve and ever change and we move along by Mr. Cowton, and I do urge you to reject it. Now, sir, most of the local residents have agreed that they're content for you to read their representations. I've got our local councillor here that is able to confirm the details in terms of the residential area, the location, the nearest location of the pub, the overview of the premises, and he's available to answer any questions. I also have a curated selection of local residents that are able to answer questions in terms of the location of bedrooms of children, in terms of their dining areas, in terms of the views that they have, in terms of the gradient and so on. Now, I appreciate that time is a factor, but we are all here to assist you, sir. And I would urge you to listen to some of the individual voices, because I can generally say what the negative impacts will be in terms of this license application, in the same way that we can all say lockdown is really, really tough, but each of our personal experiences will vary, and the emotive value of that evidence is great. But we are, sir, in your hands about how you would like to hear any live evidence, if at all, or whether you would like live evidence in response to your questions. Sir, I'm really in your hands as to how to proceed.
Thank you. I imagine some bits will come up naturally in questioning where you might feel there's something specific for you know, for one of your party to recall or to talk about. Unless there's anything specific, or there's anyone that you feel is really pertinent for us to hear from. Maybe the next door neighbour would probably be the most pertinent for me. You know, if you've got anything you would want to ask them to relay to us now, otherwise it might just come up naturally in questioning.
What I had asked them to do is to sort of just think about a brief response following my submission that was no longer than a minute to a minute and a half, so that you get a sense of the sort of personal impact, and that way we can cover that. So perhaps if I can maybe if I just call the local councillor to do that, and then the sort of 4 nearest neighbours, perhaps, we should take no more than, I know, say 5 to 7 minutes amongst ourselves to give you that direct flavour. And I always think, though I don't often say this, I always think that local residents have a far better value in terms of speaking than necessarily the barrister does. So could I ask Councillor Crawshaw to just come on for a minute and a half and just kind of confirm, councillor, the nature of the local area, the exclusive residential area, and the level of local support that you have had in opposing this irresponsible, poorly prepared, ill-articulated and badly planned application.
Thanks, and good afternoon, everybody. Apologies, my internet connection just started to play up just as you were summing up, so if it drops in and out, my apologies for that. But just to confirm, I mean, St George's Place is very much a quiet residential street. In fact, it was described by Savills as wonderful, quiet residential street on the listing for number 6 St George's when it went on the market. And so I think if the owner is selling that aspect of the street, it does give you some indication of what it's like. It's not a through road as such, but actually up at the top end of the street is a small sort of supported living area, so it's social housing and an elderly population right at the very top of the street, with then some larger houses coming down towards the bottom, and then out the back at Morgarth Avenue is again entirely residential around there. I have to say, as a ward councillor, it's not an area that I have ever previously had any particular issues with regarding noise or antisocial behaviour. But last year at the Knavesmire Gates, after the Newington Hotel had been converted into flats, we did start to pick up reports of racegoers being dropped at Knavesmire Gates and congregating before going down to the racecourse and urinating and generally being a nuisance. So we've had to work with the police to put some urinals down at the bottom as a temporary basis whenever it's a race day. So it wouldn't be right to characterise it as being that there are problems at St George's Place on race days, but there are problems within about 100 metres of the entrance to St George's Place. And so I wouldn't want to see anything that would add to that or create further problems. The other thing that I think is probably pertinent for this, just to give you an indication of noise and the potential impact on the residents. One of the biggest problems I deal with from an antisocial behaviour point of view is people on the racecourse sitting on the Little Knavesmire in an evening, having a drink with their friends, not realising that even if they're not being boisterous, the noise from a party will carry right across to the residents on Albemarle Road, which can be, 400 or 500 meters away from where they're sat. And actually at 10 or 11 o'clock on a Saturday night, a couple of times over the last summer, I walked out to try and hear what the problem was, hear the level of the problem, and then to go and actually see how many people were congregating. And as a general rule, you get maybe 3, 4, possibly 5 people in a group sitting around having a bit of a laugh, but not really doing anything particularly over the top, and their noise will carry right the way across the racecourse. And the people on Albemarle Road believe that there's 20, 30, 40 people congregating. Similarly, up on the Mount, we've got a couple of problems with Airbnbs. And Michael Golightly referred to it earlier about an increasing problem. It only takes 2 or 3 people in the backyard having had a drink or two to have a bit of a joke, have a bit of a laugh, and you create a problem. And I think when you're a resident on a street, you tolerate your neighbours doing that once or twice, maybe on a birthday once a year or a couple of times on a summer's evening. But when it's a commercial premises and it's happening every Friday and every Saturday night, that becomes really grinding for the residents. And I think that that's my concern with this. I have every sympathy with Mr. Cowton in terms of looking to see how he can adapt his business to accommodate the pressure that everybody is facing with COVID. But I think that this is it's the wrong idea for the wrong location, and I think it will have a huge impact on the residents. As Mr. Charalambidis has mentioned, he's representing a lot of people this afternoon. I have to say I've had a significant number of people contact me about this, as has Councillor Kilbane, and I'm very disappointed actually that Mr. Cowton didn't contact the ward councillors to tell us about his plans, because other people do that. That's a common feature of when businesses are looking to expand. And it's so easy to set up a Zoom meeting, especially when everybody's on a WhatsApp group. It took 10 minutes to organise a Zoom meeting for everybody to discuss some of the issues around this. It would have been very easy for Mr. Cowton to do the same sort of thing. And I think through dialogue, that's how you realise what is or isn't an appropriate thing to do in an area. And I'm sorry, but in this instance, I think it would be absolutely disastrous both for St George's Place and for Morgarth Avenue if this proposal as set out was licensed. The one other thing I should just add as well, and I do think that this is pertinent, and I appreciate I'm going slightly beyond my minute and a half I said I would do. I've spent about 20 years working around music venues, and music venues are some of the loudest licensed premises that you're likely to get. And they do get noise complaints, but I would suggest that around about half the noise complaints that I've ever known about relating to music venues have related to the smoking areas or the external areas where people congregate. It's not so much the recorded music that's the noise, it's the noise of groups of people after they've had a drink, not realizing the extent to which their chat or their having a bit of a joke with their friends carries an impact on other people nearby who are trying to be quiet. And so, again, I think in very lay terms, as soon as you're talking about 5, 6, 7 or 8 people, and in this case, we're talking about 45, 46, 47 or 8 people, it's inevitable that will lead to a lot of noise problems.
Thank you very much. Now, sir, I know your democratic services were concerned about data protection, which is why I haven't listed all of my clients or their addresses. I'm briefly going to call, I'm going to refer to him by his first name and avoid the address. But the representation that's on page 89, representor number 15. Derek, if you could take a minute to a minute and a half. I have warned you by the WhatsApp group we have. Have I lost Derek?
Yeah, sorry, I just had a note pop up saying that Derek and Amanda both dropped out.
Okay, I'm just going to move on to Mark and Helen. Mark, are you available? Or Helen, I know you're sharing. Thank you.
Hi, Leo.
Thank you. And Helen, could you confirm you're the one that took a photograph for me? Is that right?
Yes, that's right.
Thank you. So divide the time between the two of you. I'm not going to get in the way of dividing your time.
Okay, thank you very much and really appreciate the time. From our point of view, from I think a lot of the residents, the noise and disturbance is a real big thing for us in terms of our amenity, you know, our gardens, our enjoyment of living in a residential area. That's why we moved here. And also our children. The photograph that was mentioned earlier is from our son Jack's room. And he is no more than 3.5 meters from the boundary. So we are really worried about their health and, you know, their ability to be able to sleep at night. You know, everyone's talking about children's mental health during these COVID times and how difficult it all is. So you know, everything, let me start again. So all of these things have been talked about, the pods, how you're going to, you know, reduce the numbers, the smoking, but nothing's been talked about in its entirety. Now, if you put all of those together, someone walking along the gravel, someone having a cigarette, someone having a chat, you know, someone by the fire pit, someone walking in and out of the premises, someone parking, door car slamming, engines running, taxis waiting outside. I could probably go on for quite a long time, but the amount of noise, and this is, I think Mr. Golightly touched on this. We don't think there's anything you can actually physically do. I'm a civil engineer. I'm very aware of acoustic materials. There's not one material out there that will stop this noise from happening, whether it's 20 people or 40 people. The noise that this development will generate will cause harm to not just us as a family, but to Anthony next door at number 4, Derek and Amanda, Jenny, Trisha in Morgarth, and also the other residents around us. I mean, you know, we can hear Tom Jones on a Knavesmire when he's on. So a development this close, all of us will be affected by the noise and pollution. Notwithstanding the privacy issues with our children's bedrooms and our dining room. In fact, I mean, I'm sitting here right now and I can see 1, 2, 3, 5 of the pods.
And they can see into us.
And they can see into us.
And they can also see into our children's bedrooms, which we think also is highly inappropriate.
Yeah, and obviously the inaccuracy of the plans is also apparent here.
Let's stop you there, guys, because we're repeating grounds. We've made the plan submission. I just want to get someone else in. I just want to keep control of time. So
I've got a message now saying that that they're back in now, Derek and.
Yep, I've got the same message too on the WhatsApp.
Thank you very much.
Thank you. So Derek, would you please come in?
Hi there, can you hear me?
Yeah.
Yes.
Can you hear me? I can't get my video to work, so I'm still having technical issues here. Hang on. Yep. Try that.
No, sorry, but continue anyway. We can hear you.
We can hear you.
Ah, we can.
And we can see you.
Ah, good. Yeah, back online. Thank you. Thanks for your patience. Yeah, we have a significant issue really with regard to nuisance and noise. Our house is only, the rear of our house is only 7 meters from the boundary wall of this bed and breakfast, and clearly the significant development which has taken place with the generation of noise, bad language, etc., which is going to emanate from this, will significantly adversely impact on the fact that my 3-year-old has got to sleep in the rear bedroom and get off to sleep at 7:30, and this is just an absolutely terrible situation. Additionally, we work from home and run our own business. We have to get to sleep at 9 o'clock, also at the rear of the premises, and the noise and nuisance created by this, including light pollution, we believe is going to be a very significant issue. Additionally, the use of the garden, I think, will be impacted in respect of being able to play with my little one, and also in the summer months we do enjoy going out there to work, and this is going to be a significant issue with regard to the use of our our outside space.
Thank you very much, Derek. And I think I just said in the WhatsApp group, I'm going to ask Rebecca, are you by yourself or are you with Roger? But if you want to briefly come on, thank you. You can turn your camera and mic off now, Derek. Thanks.
Thank you.
Yes, I'm on my own at the moment. Roger's gone off to work. Of course, we're working at home like lots of people. Really just the same as everyone else is saying. There's going to be a lot of noise impact on us. We're a couple of doors up. We can already hear people in the gardens, and that's not a problem. But if we're going to have, 40 plus people in the garden down in the B&B, well, it's going to make a huge impact on us. We've also got children, they're older, but we've got children, university students, teenagers, people trying to work. And we just think it's inappropriate in this location. It's just not the right place for it.
Thank you very much. Rebecca's representation, so is number 14 in terms of your agenda, and Derek's is at number 15. And then just finally, I've got Sean. Sean,
yeah, sorry, Leo, I'm just unmuting. Let me start the video. Okay, hi everybody. I think it sort of goes without saying, kind of St George's Place is in a conservation area, and if you just look down, we're actually at the beginning of the road, so 2 doors down from the proposed licensing application. And when you look from one of our windows, when you look up sort of the back gardens of St George's Place and of Moorgarth, I mean, all you see are domestic gardens, and all you see and hear is normal domestic activity. And now we have very clear line of sight, even when we're on ground level, for the tops of the various pods, and it's just hard to imagine that noise is going to echo around that space and travel, and it just feels as if it completely sort of disrupts the nature and the character of a residential area, which is families and children. So thanks, Leo. That's all from me.
Thank you.
I was saying thank you very much, and I'm muted. Keep making the rookie mistakes. So I know that Paul and Caroline are on. I can't remember if that in my list they're not. They're down as saying they didn't want to talk. I just want to check that that's correct, given that they've had the patience to sit through this and participate. I don't want to gallop over them. Paul?
Leo, that's absolutely fine. I've got nothing to add to what's already been said.
Thank you very much. Caroline?
And same from me, thank you.
Thank you very much. Sir, thank you very much for letting me get everyone in. Now, I'm available to answer questions. The ward councillor is available to answer questions, and indeed all of these local residents are available to answer relevant questions as well. Thank you.
Thank you. Right, Mr. Cowton, you've got the first right to ask questions. Obviously, normally it would be 5 minutes, but obviously, Mr. Shalambidis is speaking on behalf of quite a few people, so I'm happy to extend that. So please ask away, and we'll see how we get on.
Yes, thank you very much. I'm just wondering, what is it that I could do to put people's minds at rest in terms of, it seems to be the noise being the main problem. What can I do in terms of reassuring people that it wouldn't actually be the big problem that they're anticipating it to be?
Well, noise is not the main problem. The face problem is that you failed to complete your application properly because you don't understand what it is you're applying for, and it continues to change. So you need to go back to the drawing board and actually work out what it is you want to do. Once you do that, you then need to provide a proper plan that's legible and clear and reflects the activities you propose to do. You then need to risk assess it in the context of what it is you want to do in the current location, and then set out an operating schedule that directly assesses those risks. When you've got that draft operating schedule in accordance with the guidance, though you're not required to follow this in terms of partnership, you're then to engage in negotiations with representatives from the responsible authorities and indeed local residents if you want to. I mean, to be perfectly frank, Mr. Cowton, it really needs starting from the beginning and done properly. What you've done now is just irresponsible, it's unhelpful, it's not clear, and asking us to tell you what to do to get it right just demonstrates your failure to do it from the beginning. So I'm not really going to do your job for you, but that's the outline that I would follow and that we would like to see, one that is properly considered, professional and done correctly.
So do I gather from that that there was no concession that would appease your objections?
It's not a question of appeasing objections. The reality is we don't have a clear application. It's an evolving, ever-changing thing. It's changed in its parameters throughout the course of this morning. We only heard latterly about the changes for New Year's Eve. You don't know, Christmas Eve, about New Year's Eve. The food element has changed from a pizza oven to a three-course meal. My residents are engaged and we're talking with each other, but something that is developing and evolving and ever changing is not something that we can take a view on. The reality is this is an unsuitable application. If you go back to the beginning, state exactly and clearly what you want to do in this residential rear back garden. We can then, of course, at the appropriate time, take a look at it. Though I would suggest you go get planning first, because that might be a useful step as well.
I presume that am I right in thinking that the further submission that I made to Democratic Services in the document called the Glass Garden nailed down quite a lot of things that you're saying were unclear? Is that not the case?
No, that's not correct. It attempts to amend your application after the thought. It doesn't engage with the local residents. It's got a great number of inconsistencies, which have been highlighted as a result of the questions here. We don't know about the principle of land use. You can't tell us exactly where the smoking area is. You can't tell us where people are going to be waiting, where the reception is. You're not clear on whether you've got 4 or 7 car parking. Your plan says 4, you say 7. We say it's on the ground.
The hotel, yes,
and also not on the plans. No, it's not clear, and it doesn't begin to address the concerns.
Any further questions?
I don't think so, really. Not questions, no.
Okay, like I said, after all the representatives have gone, there'll be a chance to sum up a bit later on. Mr. Golightly, have you got any questions of Mr. Charlambides?
So that doesn't...
Just trying to get it to work. No questions, Chair.
Thank you. Mr. Bryce, have you got any questions of Mr. Charlambides?
No questions, thank you.
Thank you. Councillor Melly?
Thank you, Chair. Yeah, I just wanted to check, Mr. Charlambides, that you've seen the representation from Public Protection. That's where the details are of the change of licensable hours on Christmas Eve to 9 PM instead of 11 PM. So that's from negotiations, not today, but previously during the course of the application process, but from engaging with responsible parties. Just wanted to check that you've seen that. It's on page 49 of the document pack.
Sorry, yes, sorry, apologies, of course, sorry. I have highlighted it, so apologies.
Anything else, Councillor Melly? Brilliant. Okay, Councillor Norman?
Yeah, just a couple of brief ones. Reading through some of the objections, I think there's some sort of disagreement or unclarity with regards to sort of current level of crime and disorder. I wonder if you could comment or clarify on that.
So yes,
just that there seems to be some disagreement between
Absolutely. I note that the police have agreed an operating schedule. I'm a little bit concerned about that because, of course, it was agreed on one premise, not on the amended premise, or indeed the amended premises we've heard today. The thing about the evidence that you get from local residents is they are experts at living in this area 24/7. You've already heard from Councillor Crawshaw that this has been typically a quiet area. He's not had issues in the past, but since the development, there has been an increase in changes. So this is an area of concern, and it's growing. And you've seen on the representations in regard to the concerns at Christmas time that there are. You've seen the photos of the police vans to deal with the drug users that broke into the bed and breakfast and were using it in that way. From the general character of the area, the wooded area behind is one that's prone for antisocial behaviour, disorder and crime. It doesn't need to lead to reported crime or issues. And of course, the impact of the races. You know how difficult it is, people dispersing, spending time on the streets, not moving forward, and there are those impacts. So our concern from the residents' points of view is that while there may not be any specific crimes at the time the police checked it with the bed and breakfast, the area nonetheless does suffer from certain forms of disorder, maybe even disorder once the vents and the smells get put in, as well as antisocial behaviour, and that's likely to be exacerbated. I'm on WhatsApp, so if I do something wrong, they tell me off. No, they've got nothing to add on that. Councillor Crawshaw does say that if you want some evidence from the local ward councillor in respect to the antisocial behaviour in the area and potential disorder, he's happy to speak directly to you on that as well. And I think that might be a kind of neutral piece of evidence from a local ward councillor rather than necessarily the local residents. I'm going to ask him to do that in about a minute.
Yeah. It sounds to me as if it's a sort of nuanced picture, which is why there's some contradiction. Yeah.
Councillor Crawshaw, you're as good at timekeeping as I am. So do you want to take a minute and a half or so?
Yeah, I mean, if I can just give you a picture very quickly of sort of race days and that sort of thing as one of the key flashpoints. So on the busiest race days, we have up to 40,000 people attending the race course. And the vast majority of those people are fantastic, really well behaved, a bit lively sometimes, but basically fine. But we do get a significant number of antisocial behaviour incidents, and even if you're talking sort of 1% of that 40,000 people, that's still a couple of hundred or more incidents potentially. It tends to be noise, boisterousness, but there's a lot of urinating, and that's a real big problem. Down back alleyways, down little corners. I mentioned earlier that a new incident that started to occur during the last race season was reports of the Rose Garden at Knavesmire Gates being a particular flashpoint for this. I say flashpoint, maybe not the most appropriate word to use there, but the key thing that we've noticed as ward councillors, so we hold a meeting with residents at the start of the race season, in the middle of the season, and at the end of the race season, and the police attend it and the racecourse attends it, and the reported incidents is nowhere near, like as in the police recorded incidents, is nowhere near the resident reported incidents, and I would say to a factor of 50 or 100. I mean, it's that stark, because people just don't feel that there's very much point in actually reporting, somebody chucking a beer can through a hedge or weeing against the back wall or whatever, because it's been and gone. And so what we try to do is place the police in areas where we think there are issues, and the bottom of Knavesmire Gates became an area where we started to place police last year as a result of resident reports. Now, the other issue that we get with the races is minivans not using the designated drop-off areas, but coming in and dropping off racegoers near to the racecourse so they can walk up. And again, Knavesmire Gates, St George's Place at the bottom there, these are common areas where that's happening. So it's not saying that this development would cause antisocial behaviour necessarily over and above what happens already. It's that it would add to it, it would be a further focus potentially, and it would draw it further up St George's Place where it perhaps hasn't been previously. So I hope that gives you a sense of race days. The one other thing very quickly I'll just talk to is again, people actually on the racecourse itself. We encourage people to go there because they're out of the residential areas, and we do sort of say, you know, teenagers gathering would rather have you gathering over on the racecourse than you know, in the streets or what have you. But the thing that causes the problems is the noise. The noise carries so much further than anybody expects, and that's what I get complaints about all through the summer.
Thank you very much.
Any other questions, Councillor Norman?
Yeah, just briefly as well. Well, more for you, Mr. Chalamedes, I suppose. Would it be fair to say, just in regards to some of your comments earlier, that it's particularly important for councillors on a hearing panel to be very mindful of our role in upholding the law over our role as elected representatives or people who are swayed by electoral politics, perhaps?
Absolutely, sir. This regime was designed for local people to speak to their local representatives. It wasn't designed to liberalise licensing for operators or business. And in fact, when you look at the key aims and purposes that are vitally important for you and principal aims for you to engage with, 3 of them are directed towards listen to the local residents and do what they say and think about what they say. And then when it comes to your decision-making process, I can't remember the number, I'll give it to you. I'm sure my legal colleague knows it. Paragraph 9.38, it says, make decisions in the overall interests of the local community. So yes, it's absolutely vital that is the case. And here you have the local community. You know, this isn't 1 or 2 scrappy letters. These are detailed letters supported by ward councillors. You know, they've hired me. They're all here or watching on YouTube. Their dedication to this and their level of opposition is probably some of the highest or the most sophisticated I've seen, and that carries a great deal of weight.
Thank you.
Thanks. I suppose one off the back of that, and whether it's for Councillor Croshaw or for you to answer, Mr. Chalamedes, but obviously no councillors did object to this application. I just wonder if there was any observation on why that didn't happen, or
I can answer that if you like, and I'll completely hold my hands up, and it's a mistake on my part in so much as I misunderstood this part of the process compared to a normal planning application. So I'm used to planning applications. I was anticipating coming and speaking at this hearing, not realising that I needed to be a representative in advance.
Okay.
So it's apologies, but I did discuss this with other ward councillors as well.
Thank you. Right, no questions from me. Sorry, I turned myself off there. Mr. Bryce, we now come on to your 15 minutes to make your case. So please do go ahead.
Thank you. I don't think I need as long as 15 minutes. My main concern is that capacity obviously increases all the things we've been talking about that we don't want, that Mr. Chalamedes has covered so excellently. He's taken so many words out of my mouth, but there's still there is a basement, a whole floor of nearly 100 square meters that is apparently going to be used for nothing. I can't believe it's going to be used for nothing. If Mr. Cowton, in the fullness of time, just decides to make it more bedrooms for the hotel, then that's a planning issue. But we now have the absurd possibility that the top 3 floors of the hotel will be licensed for the use of alcohol, but if anyone stays in the basement bedrooms, they won't be able to drink alcohol. Just like to point that out, seems a little bit crazy.
I suppose just to chip in, sorry, David, it's not that they wouldn't be able to consume alcohol, it's they wouldn't be able to buy alcohol, if that makes sense.
Yes, I mean that too. Yeah. There is also, whatever, if that should alter, it just worries me a bit that surreptitiously what is going to be allowed, if it was allowed today, would modify over time, and the basement would begin to be used by drinkers maybe slowly at first, but it's clear that Mr. Cowton would be able to change his mind about things all the way along the line. And I don't think there's much opportunity to modify or regulate or even know what's going on there. It will attract more people the more capacity he has. If he decides to use those rooms in the basement as a restaurant for diners, it's going to attract more people and exacerbate all the problems again. Just like to point this out. Thank you. I assume I get a right to, I've scripted a summary. Will I get a chance later to read that?
Yes. So what happens now is obviously that the same people get to ask you questions, and then I think we'll probably take a short break, and then we almost got back through the whole process in the same list, and Mr. Cowton gets the final word. So we'll start with representatives, and then Mr. Cowton will have his final summary, and then we'll go on to private session to make our decision. But yeah, that right will come soon.
Okay, thank you.
Mr. Cowton, have you got any questions of Mr. Bryce?
No, I don't. Thank you.
Thank you. Mr. Golightly, have you got any questions of Mr. Bryce?
No, thank you, Chair.
Mr. Charlambides?
So no, thank you.
Councillor Melly? Councillor Norman? Thank you. Right, so yeah, I think looking at the time before we now start summarising, which again will be a relatively long process, I think we'll have one final break. So if we can have another 7 minutes, I'm conscious, well, we have gone over lunch, so thank you for people that I'm sure have snuck a sandwich in at certain points. But if we can have another 7 minutes and come back at 22, please. Thank you, everyone, and welcome back. Hopefully, this can be the last section of today's licensing hearing. So now it's a chance for the representors to summarise their cases. And Mr. Golightly, if you can go first, please, in just summarising your representations, and you've got 5 minutes to do so.
Hello, Chair. Thank you. I think it has clarified my point really as to where we are. The application came in over Christmas, which gave us very little time to fully negotiate the conditions or to discuss the application and what was proposed. We initially had concerns about control of noise, and from what I've heard today, it hasn't really allayed my concerns, and in fact, it has raised a few extra concerns. For example, you've got the area which is overlooked by the houses where they've got children, and the hours that have been proposed, and the impact that this could have on the area. I think the location is a highly residential area surrounded by gardens and dwellings that overlook the proposed licensed area. In terms of the pubs, no sound reduction levels have been given, no qualified sound test has been made, therefore we don't know how much noise is going to be attenuated by them or how much noise is going to break out from them. This all together leads to the question of what conditions could be attached to the premises that would be achievable. I think we have to be careful when you look at the amount of objections you've got here today and likelihood of complaints, but also being mindful of setting in a condition which can be achieved. If you set a condition which can't be achieved, then we end up taking legal action later on against the applicant, then that's not in the benefit of the applicant anyway. I would therefore advise, from what I've seen today and heard today, that our concerns remain, and I would advise that the application is refused due to grounds of public protection, public nuisance, and potentially even adding about the potential harm to children as well from the swearing. Thank you.
Thank you. Mr. Shalimbides.
Sir, thank you very much. You've led a very full and frank discussion on this application. It's quite clear that the nature of the location and the character of the area has not been considered by the applicant. To paraphrase the applicant's words and adopt them perhaps inappropriately, it really is quite terrible, and that's what the impact will be. What he is doing, the application is evolving, it's ever changing to suit the way in which the questions are turning. What we need in order to make a proper determination is a proper application that has been considered, that very clearly says, this is what I want to do, this is how I'm going to do it, this is why it works in this particular area. You've not heard from that. You've heard from your public protection officer that he has extra concerns as a result of this hearing today. And of course, paragraph 9.12 tells you to have particular regard to the experts in the area. So one of the experts that's available is saying, look, this just won't work. And the idea of working up conditions on the hoof because the applicant says, well, tell me what I need to do it, is not the way forward for licensing. I remind you that what we're looking at here is to take an entirely residential area, which is entirely surrounded by residential properties, to develop a residential B&B use and effectively have a standalone glass restaurant and bar in a residential garden. I've represented a lot of dodgy applicants. I've never had to argue one of those before. I'm not quite sure how I would do it. But those are the simple facts. You've heard from the local councillor and from the local residents that it's just not suitable for the location. And so along with your environmental health officer and your public protection officer, I would urge you to reject this application in its entirety. Thank you very much, sir.
Thank you. Mr. Bryce.
Thank you. Is this the summary that I should now read?
This is your time to summarise. Yeah, you've got 5 minutes.
Right, it will take about 2. This is an ill thought out and opportunistic plan to exploit these premises solely for the purpose of financial gain at the expense of many people. It is a cynical attempt by the applicant to profit outrageously. He is completely disinterested by the effects of his operation on the neighbourhood because he lives remotely and away from it all. If allowed, this will transform the ambience and character of St George's Place from that of a quiet and peaceful residential neighbourhood to a scene more typical of the city centre. Several residents of Moorgarth Avenue will suffer considerable detriment to their visual and oral amenity and are likely to experience more problems arising from lack of parking space, along with more streets beyond. If this licence is granted, it will set a dangerous precedent for anyone to open a restaurant in any residential area, including a conservation area. The applicant has no experience of running licensed premises and has shown by his absences at critical times, such as the recent break-ins and when paying guests arrive, a considerable lack of involvement with the running of the hotel. He has also been less than forthcoming with accurate plans and has avoided making some important details clear. In the light of this, I do not believe the applicant can be relied upon to limit his operations to keep within any modified conditions or restrictions that may be imposed by the committee, and any such conditions would be difficult to monitor anyway. I trust the committee will find the most apt decision is to reject this application. Thank you.
Thank you. Right, Mr. Cowton, you have the final word, and you have your 5 minutes now to summarise your position, and then after that we'll retire to make our decision.
Thank you very much. Well, if I can just start by thanking people for their input and the time and effort that's gone into that, not least from today. And I've listened very carefully to people's objections, and in particular, I've taken on board the comments about noise and disruption to people's amenity, to their comfort. And what I would say is that we're trying very hard in our planning for all of this to retain staff as part of what we're trying to do here. I know that maybe sounds disingenuous to some of the people listening, but this is not a profit-motivated endeavour. The whole glass garden is an attempt to diversify, in the sense that to provide something unique which will mean that people actually come and stay. It is not, so the primary objective is to ensure the success of the guest house business. And with that in mind, you know, we're wanting to continue to employ the people we do employ and take on new people and give other people a livelihood as well. We did actually think it would enhance the local offer, but I do appreciate that people's worst case scenario is what a lot of the objections are being based on. If it would help the application, we would be perfectly happy to curtail the hours. In fact, we'd be perfectly happy not even to open on a Sunday or a Sunday, Monday, Tuesday evening, for example, because you know, we'd almost certainly not be opening anyway. We just wanted to have maximum flexibility. We would also be perfectly happy to limit the number of guests in the garden area down to 24 if people were feeling that, you know, 48 was going to, we don't envisage having 48, but that would be the maximum capacity. But if that's an issue for people, we would be happy to mitigate that and go to 24 as a maximum. In terms of the race days, I don't see how that's still going to pull people up to St George's Place, because we're not offering a bar. We would also not have any seating in the garden area for guests. So all the time we would be focusing on the initial concept, the original concept, which was providing safe dining areas, not just safe from COVID, but also comfortable and cozy and warm so that people can have a private dining experience with or without COVID, to be honest. And we would not seek to attract any type of customer that would detract from that atmosphere. So that's all I can really say. And I do understand that the original application was short on detail, but I did submit very detailed operating principles subsequent to that, which took into account many of the issues raised. That's really all I have to say. Thank you.
Thank you. Members, is there any final points of clarity you would like to ask from anybody? Taking that as a no.
No, thanks.
Brilliant. Sandra, any legal advice or anything you'd like to say or make any points to us before we retire?
No, Chair. It's just say for that the legal point that I had a brief discussion earlier on with Mr. Chorlambardis about during the hearing, you may recall, Chair, about the extent to which regulated entertainment form of music can be controlled through conditions on a premises license. Just to let the hearing know that my position remains that, as I think I suggested earlier, that the effect of the deregulation legislation was to disapply music-related conditions from a premises license unless they have been attached following a review hearing. I don't know whether Mr. Chorlambardis has had a chance to consider the point further, but that's my advice. Unless Mr. Chorlambardis can say anything that would persuade me otherwise.
So I suspect it might be academic in the following sense that all the parties that are making representations are asking for the matter to be rejected, and Mr. Cowton hasn't suggested any conditions, though he himself has said that there will be no regulated entertainment, so you can take that on board. The difficulty I find is I look at section 177A and see what it says. However, section 177A, talking about the suspension, nonetheless doesn't say that the imposition of conditions can't nonetheless be considered on a case-by-case basis. And it can't be right because it hasn't said that it fetters the discretion of councillors to put those conditions on. The question is whether or not, once those conditions are on, whether they would apply, and that may well be an argument for a later day. But they can certainly put on those conditions, and the halfway house between you and I, Sandra, is that they can go on the licence, but they are suspended. Though I would go further to argue that if they go on the licence with an appropriate statement that says they're not to be suspended, then they are to have effect. But I think that's how section 177A works. But like you, I acknowledge that it is a grey area which has never really been clarified. I hope that's helpful. Somewhat.
Thank you. Members, obviously, if there was any conditions that we were thinking around now, there's obviously a chance to discuss those. Is there any conditions at the minute that you feel would be worth discussing in public before we retire to make a decision?
I think we brought quite a lot of them up. Go on, Councillor Melly, sorry.
Yeah, I was just trying to remember which ones I've already asked about, because we have raised a few already. I'm trying to remember if there's any that I've thought of but not asked about.
That's fine.
What I've noted here are that we've just had a reduced limit of covers in the garden, potential limits on the areas that are licensed, some conditions offered on hours, that are more stringent to what I applied for, and that we've had table service and with substantial food offered. I think that's
Yeah,
fair.
that's what I've got in my notes as well.
Yeah. I suppose one question from me, maybe Mr. Cowton, if we looked at a condition that only allowed alcohol service within the premise and not outside the premise, is there any observation on that?
Well, yeah, I mean, we're open. I'm open to anything that makes it work, because the objective is not to enable people to come and get legless. The objective is for people to be able to enjoy a meal in safety, in comfort. Now, the alcohol license part of it is to be able to serve them alcoholic drinks with their meal. That's the whole point. Now, if we can only do that inside the hotel, I would imagine, and that's obviously going to, as a customer, I wouldn't be hugely happy about that, because I'd want to dine in the dining pods. I wouldn't want to dine in the dining room, I don't think, because the whole concept of the restaurant isn't the dining room. The whole concept of the restaurant is, the dining room's there anyway, that's a fact. But it's more important for the enjoyment of the glass garden that people have the option of ordering drinks with their meal. So it would be a shame to limit it to the dining room. It would be of little use to us as a business to do that, but it would be better than nothing. But it sort of makes the whole process a bit pointless.
Thank you. Right, so
if I could just observe, so the dining room is the dining room on page 35, that in earlier conversation, Mr. Cowton agreed to limit the food to there and to no more than 16 covers. So those would be that would be the licensable area, the ground floor dining room, no more than 16 covers, as per his earlier responses.
Thank you. So what will happen now is we will go and make our decision in a separate on a separate platform, and what will happen then is the meeting will close, and the Democracy Service, once we've made a decision today, will then write the decision notice, and it will be published on the council's website later this afternoon. Is that's still correct, isn't it, Fiona?
That's correct. It won't have the detailed reasons on it. It will just say, you know, it's either granted or not, and any conditions if it is granted. So it won't go into detail until the decision letter is sent out.
Thank you. Yeah, otherwise it just becomes a very convoluted process to try and leave one platform, come back to another platform, and who knows how long we might take deliberating. So I think the safest way is for us to close the meeting now. We'll make a decision, and that decision will be published later on this afternoon. But I want to thank you all for coming. Obviously, it's been a very, very long day, and obviously a huge amount of interested parties and people watching it on this platform and obviously online. So, you know, thank you, Mr. Cowton, thank you, Mr. Shallambedes, Mr. Bryce, and also to our officers, Mr. Golightly, and everyone that supported us to be able to hold the heating in such an efficient manner, if I may say. So yeah, we'll retire now, and the decision will be published later on today, and obviously that will be communicated wider once the full reasons are there as well.
Thank you.
Thank you. Thank you.
Thank you very much.
Thank you.